Hello, everyone. Good evening. Oh, oh, thank you. Hello. Welcome to tonight's live. We've got a few topics to actually go through tonight. Oh no, I always pull up the docket before I come on. And I just noticed that we have another order that just came through. Let me take a look here at the docket. Oh my goodness. All right. We are ready. Oh, good. Good. Oh, I think that's fair. That's absolutely fair. Yep. You should always, whatever your spouse does, you should always be the one supporting that. So, absolutely. Okay. So I'm just taking a peek here, just real quick. All right. So, welcome everyone. Welcome. We've got an interesting night tonight. Hello, welcome. I have a quick question. For family law, I'm not really represent yourself instead. Yes, well, okay, great question. We have a lot of pro se people who try to work through the system themselves, and a lot of times our states actually have a pretty good set of guidelines and assistance on their government websites that kind of set out what to do if you are pro se and you're representing yourself for a divorce proceeding. So I know, for example, in my state, you can put in the name of your state and pro se and divorce, and it will take you to a website that kind of walks you through the process. So those should be able to help you find a good spot. It can be. It can be for sure. But yeah, if you've got limited possessions, but you know, it's tough to go through. I have many people that reach out to me just because they want to make sure that they're doing everything okay. And so sometimes you can kind of do like an a la carte situation with an attorney where you can say, look, I've got documents and stuff, and can you just look at them? And sometimes attorneys will offer those kind of a la carte services to help you make sure you get everything straight. Yes. Criminal trials, would be definitely difficult to represent yourself. A lot of issues, but yeah, and especially if children are involved, that can get complicated. But I've seen the states that I've looked at have done a pretty good job of explaining kind of our pro se rules when it comes to divorce. So yes. Yes, it probably could be more vague, but I'm not sure how. That would take a lot. That would take a lot more effort. I wasn't sure exactly how to title this for tonight, because I think there's a lot of different ways of looking at it. But I wanted to kind of go into the ways that we go about establishing evidence, and when we're looking for true facts through the legal system. And they will be meeting with the judge on Friday. Yes, and it looks like there's a motion for exclusion of time under speedy trial that was just filed too, but it's only 2 pages. By the defendant did file something. It looks actually pretty aggressive, but you know, that's what you do. Do I still take cases? I don't take any current cases. I'm not taking clients at this time. I do make exceptions where needed. So it's not that I can't come back in, but right now I'm pretty well situated for what I can really handle. So at this point, so nope, I'm just getting started. Hopefully this will be interesting for some people and helpful. So let me go ahead and kind of jump in here. I've got a couple of cases that I'll be talking about tonight. And it's the Dobert case and Illinois v. Gates. And both of these cases really set out for us what the standards are for court when we're looking for evidence and what's the truth. I think there's been a lot of question about what can you believe, what can you not believe. And I think the legal system and what we put in front of our jury is one of the processes that is pretty well structured when coming together to figure out what's the truth and what's not the truth. So I wanted to kind of take us through some of the rules that we use in court that are really important to us in figuring it out. Now, there's a big way that we go about trying to figure out stuff, and I don't, there's a scientific, I guess, procedure. That's probably not the word. Method, I guess. There's a method to science, and that's great. I'm not a scientist, but I do have some rules that I use in order to kind of figure out if something's correct or not. And one of the very first things I always ask myself when I'm looking into something is, whether or not I can come up with a question and an answer that's valid. So I really want to start with this idea of, I'm not going to use the science language, so forgive me, but when we hear something or we take something in, like somebody suggests some kind of an assumption or an issue, then we just base whatever we think about that off of, what we know, what we've been taught, and so on. So this particular analysis, there's lots of names for it, but what I call it is, my quick and dirty. And it's the way of taking in a question and then just immediately coming up with an answer. So, it's quick and dirty. It's like, okay, so the question could be something like, can you say things publicly to incite a riot and use freedom of speech in order to have that be your defense? So that's the question. That's the issue. So quick and dirty, right off the top of my head, because I know the language of the First Amendment and freedom of speech, I'll say my answer is going to be no. That's my quick and dirty. But now I need to figure out if that's correct or not. So what I do in order to figure that out is I look to the evidence in my field. Now, I think the biggest issue we have right now is that we don't really trust our experts. We don't really have a lot of faith in them, and we can just use the, let's just use the U.S. v. Trump DC Indictment, just as our fact pattern here. We can just use that to help us learn the concepts. And so let me just grab that indictment real quick, and we can do our analysis that way. So let's just say, it's I think it's a good example. I've got so many different ones that are marked up a little bit, but so let's just take a look. So here's the question. We have, let's just look at obstruction of a proceeding. So this is the law, and just based off of what I know about the criminal justice system, I have my own thoughts, but in order to bring an indictment, we've got to have probable cause for evidence. Now, I would, remind everyone that We had some January 6th hearings, and they were really, really long. Does anyone remember that back in the Senate or back? We had a big committee, had a ton of people testifying. We had hundreds of witnesses testifying. Now, I didn't really pay attention to a lot of that because it's Congress. And quite frankly, when it comes to politicians, I struggle. I struggle a bit. So although I wasn't discounting what was being said, I found that source to be difficult to find credibility with. So I didn't really pay attention to those hearings. What I did do, though, once I saw a grand jury indictment come down, was I said, wow, this is different now, because I've got a source I trust, which is a federal courts. And so now I need to take a look at this and figure out what all the pieces are. Yes, and what I've done after I found court records that I felt were reliable, I've gone back and I've listened to a lot of those hearings. And when I look at it, now I can see how that evidence is used in a court document and what's trustworthy and how the probable cause has been supported. And the just small amount of evidence set out in this indictment compared to how much was testified to is really vast. I mean, it's a huge amount. So I would say one of the, yes, you have to kind of, in my comments section, it gets a bit dicey, but when you're reviewing your sources, you need to figure out who you can trust. And for me, my source is the courts. I trust the courts because I know how they work. I trust the records of the court. I trust the experts, the people involved in the court. So when I'm looking through evidence in a case like this, where I'm just looking at probable cause, I'm assessing the evidence with regards to the rules of evidence, because that's our procedural rules that guide it. So if we go through again, and just using this as an example, let's take a look at the evidence that we have. Let's take a look and decide, what we have for figuring out what the truth is. Because when we call in a jury, we're asking that jury to make that assessment. So we've got our co-conspirators here. And again, this is kind of marked up from one of the many times I've gone through this. But let's just take our first piece here and go to the federal government function. That's an essential element to what's been charged. He's been charged with impeding a federal government function. So they have to show that there was a federal function going on. They're citing the act. They're citing the law. So if I'm trying to figure out if this is truthful or not, what are my sources? I've got the Electoral Count Act here, and I've got the Constitution. I don't think it gets much more truthful than the Constitution or a federal act. So we've got the law set out here. So this isn't something that is a debatable fact. This is truth. And so I would ask at this point, can we believe, let's just start here. Can we believe that we had a government function on January 6th? Did we have a government function? So that's the first question. Did we have one? And the government function that's set out for the Electoral College in the Constitution, along with the Electoral Count Act. So there are certain basics given to the jury that are just facts, right? Just truth. So, when we're looking at that, now we start to see, well, when are we starting to drift away from the truth? And why are so many people, trying to discount or discredit the facts that are given? So let's take a look. We've got manner and means. Now, let's go to this very first piece. The defendant and co-conspirator used knowingly false claims of election fraud to get state legislators and election officials to subvert the legitimate election results and change electoral votes for the defendant's opponent, Joseph R. Biden Jr., to electoral votes for the defendant. So even with this first sentence, what kind of evidence do you think we've got? False facts. Well, that's what I'm asking about, Greg. What evidence do we have here? What evidence? So if we need to prove this, let's just say we're the prosecutor, we're the government, and we need to prove the defendant and the co-conspirators knowingly used false claims to get state legislators and election officials. So we're going to need our witnesses, right? We're going to get state legislatures and election officials to come in and testify. And they're going to testify to what they know about the subversion of the legitimate election results and changing the electoral votes. Now, when these guys come in and testify and explain what happened, the question is, do we believe them? Right? Do we believe these state legislators and election officials that are mentioned throughout this entire indictment? Do we believe that when they say they were contacted by the defendant or various people, or co-conspirators, do we believe what they say? And I mean, that really is what the issue is, because some people are saying, well, you know, maybe they were put up to it. Let's just throw it all out there. They were put up to it by the Democrats. So are you saying the Democrats got a hold of Republican state legislators, asked them then to lie in front of a grand jury and Congress, because all of this goes into Congress as well, in order to come up with this scheme in order to charge him? Yes, they are under oath. They are under oath, but these are the witnesses. So when someone says this information is fake, this information is a lie, we're talking about majority, minority leaders of the House of Representatives and the Senate and state legislatures, as well as election officials in charge, so secretaries of states in charge of these elections. So they are going to come in, or did come in, and testify to the grand jury that there were no problems with the election. That's how they're going to testify. Yeah, it's federal prison if they lie, right? They're under oath, and they can only testify to what they know under the rules. So, you know, again, I'm like, okay, well, let's just say then we've got a whole bunch, and they're all listed here, and we'll go through those, but we've got a whole bunch of state legislatures. We've got a whole bunch of election officials. They're testifying about what was said to them and what information they know. They are all testifying. Every single one of them is testifying that the election was legitimate. All of them are testifying to that. So when people are saying the election was illegitimate, are they saying all of these state legislators and election officials are all lying? Is that where we're at? Every witness is a Republican. True. Yeah, I mean, I don't know of any of them. They can't testify hearsay, though, so not what they were told. They can, Josh, they can testify to hearsay. And hearsay is one of those rules that I think a lot of people get a bit confused about. All right, so under the hearsay rules, we have statements that are specifically not hearsay. So a declarant testifies and is subject to cross-examination about a prior statement. So whenever any of these people come and sit on the stand and get asked about prior statements they made during a congressional hearing, say, or during any kind of recorded or under oath investigation, all of those statements then are seen as not hearsay if they're inconsistent, but if they are consistent, and so on. So we're rebutting implications, rehabilitating, and so on. So I guess what I'm showing you here by looking at 801D is that I'm saying, too, when we flip the pages, we've got pages and pages and pages of exceptions. I'll keep flipping. All of these are exceptions to the hearsay rule, all of these. So under any of these rules, statements can be used in court. Well, now, RJP, that's not very nice, isn't it? So hearsay is like gossip, I suppose, to some degree, but there can be reliable hearsay. And that's what our exceptions are for. So if you have a statement, you go into a doctor and you see the doctor and you say, I was in a bar fight and this was done because somebody hit me with a particular object. Now, if we're in court and we're at trial and you call that doctor in and you've waived privilege, can that statement be brought in that they were harmed with a bottle? Well, it's hearsay technically, right? So should it not be allowed in? They used a weapon. Okay. Should that not be allowed in because it's hearsay? No, it's allowed because we have a statement made for medical diagnosis or treatment. So that kind of a statement's allowable. A statement for recorded recollection. So, on a matter the witness once knew about but now cannot recall well enough to testify fully and accurately. Was made or adopted by the witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. Or records of regularly conducted activity, an absence of a record, present sense impression, excited utterance. So any statements made while someone was afraid in a particular situation, any of those statements can be used. And yeah, they're hearsay, but there's an exception. So when you say hearsay is not allowable, that's not true. There are tons of information. Right, exactly. And if you have the defendant making statements against the defendant's own interest, those are all admissions. Now, you may think of an admission as someone going into the police and saying, I did it, but an admission is when you say something against your own interest to another person. That statement can be used against you in court. It doesn't matter if you knew it was recording or not. The book I'm looking at is the Federal Rules of Evidence. I just happen to have it in this book form, but it is available online. You can go online and find it, and you can find a free copy of it. So let's just go back here to our first piece of evidence in the indictment. I just randomly picked this page because it's really the first batch of evidence. So we've got this idea. We've got witnesses we're going to call in order to talk about the legitimacy of the election. That is on the pretext of baseless fraud claims. Now, in order for them to claim baseless fraud claims, they're going to need witnesses in order to support that. Right? So who are they going to call in? Probably election officials. Who else can they call in to show that the claims that were being made were fraudulent? Well, anyone involved in it that had done any kind of investigating. So the Department of Justice investigators, any of the election officials, and so on. The defendant pushed officials in certain states to ignore the popular vote. All we need then is the testimony of these officials to come in. What's your position? Well, I'm the blah, blah, blah of the House of Representatives for the state of whatever. And were you asked to put aside the popular vote? Yes, I was. That's the testimony that's needed. That's it. That's all that's needed and may have already been given to the grand jury. So that's one piece. Disenfranchised millions of voters. So let's take a look at that. How are we going to prove that? How are we going to prove that millions of voters were disenfranchised? What evidence would we need for that? I think this would probably be a good place where you would put different social scientists who had been conducting any kind of investigation and so on. So I think any of that could come in. This is such a vague premise that it's not going to be easy to prove. So is this a problem with their evidence? Yeah, probably. But is it necessary in order to prove the prongs of their case? Probably not. So I heard him say this to me hearsay, ignoring the exceptions, or is it eyewitness testimony? Okay, Matthew, that's a great question. So it depends on who's doing the talking. If it's one of the defendants, then that's a statement against your interest, so that's not qualified as hearsay. It's kind of seen as not hearsay. If it's another person who's saying, oh my gosh, I'm in fear for my life, that would be hearsay technically, but it's an excited utterance. So you could testify, and the man next to me said he was in fear for his life. That's excited utterance, so that would fall under an exception. The witness's testimony, the eyewitness testimony, would be of that person next to them making that excited utterance. Wouldn't purposefully ignoring the popular vote be disenfranchising those voters, though? Yeah, that's a great point. That could be a great point. So if we pull in the election official and we say, hey, what did the defendant say to you? The defendant told me to ignore the popular vote. Then the inference could be, now we're disenfranchising. I'm not sure how far that inference would go, but it'd be worth it. And dismissing legitimate electors. Now we've got to have evidence to show that legitimate electors were being dismissed. So who do we have as witnesses then that could dismiss these electors? Who was involved in that? And those are the people who are going to be testifying and ultimately cause the ascertainment of and voting by illegitimate electors in favor of the defendant. Now we have this other group of people. We have these illegitimate electors, and whatever their understanding was isn't essential. They're going to testify. Were you supposed to submit votes? Yes, we were. And then did you submit votes? Yes, we did. Are you legitimate electors? No, we are not. That's the evidence that's needed. Yes, a lot of people, absolutely, a lot of people would be involved. Yes, the illegitimate electors piece is so, there's so many pieces to it that can be proven, because you have the people who wrote the certifications, the people who delivered the certifications, the state officials that kind of tried to open the doors for the illegitimate electors. We have all of that evidence and all of those people that can testify to that. They wrote it all down. Yeah. It will be a long, long case. So that's our first couple of pieces. Again, I'm just using this as an example. Next we've got, and again, they're going into the manner and means of how this was done. But let's look here at the next piece of evidence that was given to the grand jury. Illegitimate, yes. Alternate, I think they're using those a bit. It depends on which section of the indictment you're looking at. The defendant and co-conspirators organized fraudulent slates of electors in 7 targeted states. Now that, again, how can they prove that? Well, they have all of the certificates, right? They have all of the false certificates. So that could definitely be presented to show that there were slates of these kinds of electors. That would be also admissible in court. Is it common for federal indictments to be so detailed? You know, I think they can be. I think in a case like this, they really have to be this detailed. Am I a federal prosecutor? No, I most certainly am not. I am a licensed attorney. I've done criminal law on both sides. And I teach criminal and constitutional law when I can, when I have time. Yes, affidavits as well. They signed their name. Yep, exactly. All of that's proof. All of that would be evidence that would be allowable in court and to this grand jury. Attempting to mimic the procedures that the legitimate electors were supposed to follow under the Constitution and other federal state laws. Again, all we have to do then is show what these certifications were like and also have the fake or alternate electors testify. If they testify, let's just pull in, alternate elector number 1 and say, hey, what were you asked to do? Well, I was asked to go in and vote at this date and this time, at the same time as the regular electors were. And why? Well, because I was supposed to be an alternate in case the litigation went through. That testimony of each and every one of those illegitimate electors is going to support this premise here that they're setting out. This included causing the fraudulent electors to meet on the day appointed by federal law. That would be pretty easy to prove, on which legitimate electors were to gather and cast their votes. They cast fraudulent votes, and again, there's our act. So they'll just ask them, so what day did you go in and do your votes? Okay, and were you told that this was a legitimate vote or not? And really kind of dig into those kinds of questions. For the defendant, and signed certificates. Also, we've got the signature here of certificates that were signed. Another piece of evidence. Falsely representing that they were legitimate electors. Some fraudulent electors were tricked. I think any of the electors that were tricked when they go to testify in front of a trial jury, what are they going to testify to? They're going to say, hey, we thought this was only going to be used if this went to trial. Please read the Bible. Oh, I do read the Bible, but I'm not reading it at the moment. Tricked into participating based on the understanding that their votes would be used only if the defendant succeeded in outcome determinative lawsuits within their states. Again, this can be direct testimony given without any issues. Please read the TV guide. Well, I can look at it online. All right. And then, of course, the defendant never did succeed in any outcome determinative lawsuits. Again, another thing that can easily be proven. The defendant and co-conspirators then caused these fraudulent electors to transmit their false certificates to And again, sorry about my marking up here. I've marked up this indictment so many times. The vice president and other government officials to be counted at the certification proceeding on January 6th. So, of course, we would have evidence to prove that as well. No, it's okay. It's okay. No, I get it. I'm happy to read anything. Yeah, I was going to say, does the TV guide still exist? Is it bad that I even know what the TV guide is? All right, so let me skip through the means and manner. Let's go to our next set of evidence that they're showing again. And I think this is important too, because we have all of these witnesses that they've cited. So again, all of this is public record. I'm not going through and doing anything that's not already been discussed beforehand. So let me just make sure. Am I in frame okay for everyone? Let me just double check. Okay. All right. Yes. Oh, good. Let me know if I'm out of frame at any point. I've got a couple of different checks in place, but which indictment? This is the Washington, DC indictment, and I'm going through the different pieces of evidence in order to determine how this evidence can be presented in court, as well as how we would determine whether or not it's truthful evidence. There's no, first of all, there's no gag order. Move to the left a little bit. There's no gag order on an indictment. This is a public indictment. If there is any sensitive evidence that would come out, or even something that I would view as sensitive, I wouldn't share it. But this is a public indictment. Anyone can go online and find it. All right, so let's, a little more to the left. There we go. Yeah, if I move it too much more, I won't be able to see it on my screen, I'm afraid. So, all right, there we go. Let's just break down these next pieces of evidence again and talk about how this evidence would be appropriate or not under the rules of evidence and when we're looking for the truth here. We've got the defendant's vice president who personally stood to gain by remaining in office as part of the defendant's ticket. So first of all, how do we prove that? That would be just through a direct question, right? What would happen if the president had remained in office? Well, I would have gone on as the vice president, so that would be pretty easy. And whom the defendant asked to study fraud allegations. Again, how do we prove that? Well, we just would ask him. Did the defendant ask you to study fraud allegations? Yes, he did. And then what happened next? He told the defendant that he had seen no evidence of outcome determinative fraud. So we now have a vice president of the United States stating the president asked him to look for fraud and that he found none. That's testimony. So when we have this question of, it's all made up, it's all fake, well, we've got one person here, the vice president, who's saying, we don't have any fraud. But let's not just look to one. We want to look to the totality of the circumstances. So let's go to B, senior leaders in the Justice Department. So all of these guys and gals can be pulled in. Appointed by the defendant and responsible for investigating credible allegations of election crimes. So it's their actual job to find election crimes. That's their job. They told the defendant on multiple occasions that various allegations of fraud were unsupported. So now we don't just have the vice president who said there's no fraud. Now we have a group of leaders in the Justice Department saying, there's no fraud. So again, we have another piece of evidence here. Will Pence need to prove he actually looked for fraud? I think his testimony of him saying, I looked into it and found nothing would be plenty. I think if the prosecutor wanted more information, they would go forward and ask further questions. But it seems like the vice president had very good notes. And if you've got notes on things, then that's going to be very helpful. And our juries really like notes also. They like to know that, the information isn't just something you remembered that happened. You actually wrote down what was going on. So now we've got two. We've got the vice president. There's no fraud. We've got senior leaders in the Department of Justice appointed by the defendant. We've got no fraud. This is the next piece of evidence here. The Director of National Intelligence, all right, defendant's principal advisor on intelligence matters related to national security, disabused the defendant of the notion that the intelligence community's findings regarding foreign interference would change the outcome of the election. So now we've got more people testifying. There was no fraud regarding foreign interference as well. Yep. And then next we've got CISA, which is very important. And we're going to just need to call in witnesses here. And we're going to say, hey, what happened? What did the defendant talk to you about? And they're going to testify that there was no evidence of any voting system that had been compromised and that it had been the most secure in American history. The CISA director is also going to talk about how the defendant had made certain statements to him and then that he was fired. So that information is actually going to be able to be testified to as well. All of that is personal knowledge that this witness would have regarding the situation. You're reading a document from personal who will never tell the truth. Well, and that's what I'm talking about, because if we just take a moment here, okay? We're just on D. I've got, this is what I'm looking at. I'm looking at a vice president of the United States. I'm looking at senior leaders from the Justice Department. I'm looking at the Director of National Intelligence. I'm looking at the Department of Homeland Security, Cybersecurity, and Infrastructure Agency. And I haven't even finished. We're four bits in here. All of these guys are saying the same thing. So are we supposed to discount everybody? Is a question of credibility for everybody? Is everyone not credible that I've read up until this point? I mean, that's the question. That's the question. This is the indictment that I'm going through. Yeah, I mean, I can understand if you're like, well, I don't really believe the vice president. I get it. But then do you not believe the senior leaders of the Justice Department? Yes, they're all his appointees. And then what about the Director of National Intelligence? And again, I haven't even finished. We're already in D here, only in D. And I've already got a question saying, hey, it's all false. But then I'm like, well, that's one of the reasons I wanted to come on here tonight, is because I'm like, well, what would make, we've got 4 different sections of people involved. So if everybody here is lying, I mean, how is that possible that this many people would come together and lie about it when we're at the 4th piece here? I mean, I think that's a good question. Why would you believe the Justice Department? Okay, that's fair. We don't like the Justice Department. Let's cross them out. I still have the Vice President, the Director of National Intelligence, and CISA. And I haven't even gotten into the White House attorneys. Let's just include them. We don't want to leave them out. But I still have these other 4. So, okay, you don't like the Justice Department? We'll cut them out. What about these guys then? Do they count? I mean, that's the thing, is that there's so many different, you don't want to believe the vice president? Okay, sure. Let's take off the vice president then. For some reason, let's pull him. You know what? I tell you what, let's take out the Department of Justice and the vice president. So now I've got the Director of National Intelligence, I've got the CISA agency here, and I've got the senior White House attorneys. Now, are these guys then not trustworthy either? Because that's fine. We can do that. Let's take those 2 away. We still have these different branches, and that's even before we turn the page. Because look what happens when we turn the page. We have also senior staffers. We have state legislatures and officials and state and federal courts. So that's, now we've got 6 other things. So let's not look at the vice president. Let's not look at the Department of Justice. That's fine. Don't do that. But now we've got so much. We still have so much. It's the government. They all lie. So, okay, fair. Okay, I get it, Donnie. So what I'm trying to say is the evidence here, we can't trust the vice president. We can't trust the senior leaders of the Justice Department. We can't trust the Director of National Intelligence. We can't trust CISA. We can't trust the senior White House attorneys. And you cannot rely on senior staffers who were his own people, state legislatures and officials not even part of the government or the courts, the state and federal courts. So we'd have to put all of them away, all of them to the side, and say none of them are trustworthy in order to get rid of the evidence here for probable cause. That's a lot. I mean, if you just look at it from a point of view of, I've got A, B, C, D, E, F, G, I've got H, I've got 8 categories of witnesses. Not just I don't just have 8 witnesses, I have 8 categories of witnesses, and not a single one of them is reliable. I mean, I struggle with that because how our rules of evidence work when it comes to witnesses testifying and witnesses being available and the kind of evidence that's allowed. So even if you take all of the government actors out, including the state actors, not even the federal ones, all we're left with are state and federal courts, and they had held in over 60 cases, that there was no fraud. So do we not trust our state and federal courts then either? I mean, I think that's a good question. I mean, I don't get it. And also the other question too, which I find honestly is one of the things that I think is, like these are his trusted people. These are people that he put into these positions and he trusted them, and which is fine, and maybe he doesn't anymore. But these were not people pulled in by Congress. These were not people approved of by anyone other than the president. The president of the United States chose these people. And so why is it that we can't trust them now? Because they're saying, all of them are saying the same thing, but we're not able to trust them anymore? Those are the kinds of questions that, we have to look through and use that critical reasoning and try to figure it out. Because again, we can even cut out all the government actors, but then we've got White House attorneys who have their own votes, their own ethics. And if we cut everything out, what about the courts? There would be nothing left of our government whatsoever. There would just be nothing left of the government if you really believed that not a single entity or category of people was saying legitimate things that they're testifying to. That's a lot. Yes, and the court will look and see the discovery, but I would also remind everyone that, we were really privy to the discovery. If you go back and look at the congressional hearings, we heard sworn testimony from all of the witnesses. Not all of them, but a lot of them. So again, at the time, I certainly was like, I'm not sure about this. But now that we've got a court record, a court indictment by a grand jury, listing out the information that was given there, we can see the people who testified under oath. Yeah. The congressional hearings were one-sided. That's true. There was no cross-examination. That's also true. And we have to have cross-examination. But we also had, I think, almost 200 witnesses? I mean, that's just quantity-wise, that's a lot. That's a lot. Yeah, and we're certainly not trying any cases, but we're looking for the truth. This is what our juries do. We call them our fact finders because we put this kind of evidence in front of them and we ask them to determine what the truth is. What are the facts? What did happen here? So that's kind of what, I'm trying to use this as an example to say when you're looking through and you're finding different pieces of evidence being talked about, we've got opinions all over the place, but when you're looking into an indictment, I mean, these are facts. These are facts that people have testified to. Now, when you testify, that is your facts. Now, before we get too far into that, let's just talk about what witnesses are allowed to testify to. Let's just clear that up, just right out the gate. Let's clarify it. So we have witness testimony here. Let me pull up the rule. When a witness testifies, this is what's required. A witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Evidence to prove personal knowledge may consist of the witness's own testimony. This rule does not apply to a witness's expert testimony, which is Rule 703, and we'll get into that in a little bit. So in order to testify in court, they have to be able to testify to their own personal knowledge. Now, whether or not they're credible, that's something that can be discussed on cross-examination, and that's how that works. But when it comes to being able to testify for personal knowledge, that's what the rule says. All right, so we've gone through these different elements. Let's take, oh my goodness, thank you, Raymond. Let's take a look at some more evidence here, because we've got all different kinds of evidence in this indictment, just different kinds. Testimony does not make it fact. That's true. But what about the testimony of 200 people? Does that make it facts? I mean, that's just a question I'm asking. I mean, what is it when we look and say we need the facts? How do we find the facts? Don't we find the facts by having people testify? Isn't that where we're finding facts? Right. So, I mean, maybe the facts of the first 100 we don't agree with. It's not good. But maybe the second 100 set of witnesses, those facts are okay. I mean, that's the question. 200 paid Antifa protesters. Who's got that kind of money to pay 200? I mean, really? And then 200 people then testifying, and each one of them can look to 5 to 10 years in prison if they're perjuring themselves. So, I mean, again, I think I've asked this question before. How much is that worth to you? How much money would you accept in order to falsely testify knowingly and knowing that you could go to federal prison? How much money would that be? And where would that money come from? You know, I mean, I think that's a good question. Sure, money is at the root of a lot of things here, but that's the question. I mean, if I've got 200 witnesses, how much do I need to pay each of them in order for them to perjure themselves in court? It's a lot. Yeah, it's a lot. Cult members will go to jail. Well, yikes. Oh my goodness. Yes, and that's what I'm saying. I think we should all be asking those questions. I don't think it's bad to ask questions. I think it's always good to ask questions. But then it's also good to use, reason and logic in order to figure out if that's, in the realm of reality, if that's possible. Yes, it does get a bit crazy, but I still think we're doing okay. I think we're doing okay so far. That's how the mob operates. Well, I've been going through the RICO statutes. I've been trying to get a post together on that. And I'm planning to do a live just going through RICO because there's a lot of very interesting points with that. So, all right, let's zip down then into our next batch of evidence here that they use to give to the grand jury and how they would support this in court. So again, we're just going through how we find the truth in the legal field, what rules we use to determine it, and so on. So we're just chatting about these kinds of issues. This is all public document. We're just chatting about it. So I think this is a good tool to learn off of because we have a lot of information. So let's go down here. The charge is he made knowingly false claims throughout the post-election time period, including those below that he made immediately before the attack on the Capitol on January 6th. Now, the reason why this is, thank you. The reason why they're pulling this out is because they're saying he widely disseminated false claims of election fraud for months, even though he knew. So we've got this intent level that's being discussed. Now, one of the talking points that I think I've heard some people say is that, well, his lawyer told him. And I'll say this like I've said it before. And, if your lawyer tells you to, go and do something illegal, like, fraudulently mail in tickets to another state, because that's a federal offense, Are you going to do it? No. Your lawyer's not going to help you. Your lawyer's going to also get into trouble. But just as a side note, as attorneys, and that's bad if we're doing that. And the perfect example would be the O.J. Simpson situation in Las Vegas, right? He said, look, I could go and get all of my property. My lawyer told me. And they said, well, that's not how that works. And now you're going to prison. So here we go. The defendant insinuated that more than 10,000 dead voters had voted in Georgia. Now, let's pause for a moment. Let's talk about the First Amendment, okay? Let's talk about that First Amendment. The defendant insinuated that more than 10,000 dead voters had voted in Georgia. We can say whatever we want, right? We can say the sky is purple and, I'm half zombie. That's fine. You can say that, sure. But let's look at the context. Just 4 days earlier, Georgia's Secretary of State had explained to the defendant that this was false. So now we don't just have a statement here that we're making just for fun. We're having a statement that we have someone at the level of the Georgia Secretary of State saying that's wrong. So I'm going out in public and I'm saying, zombies are taking over the world. Meanwhile, the Anti-Zombie Commission's like, no, they're not. So now when we look at that context, we've got issues going on. The defendant asserted that there had been 205,000 more votes than voters in Pennsylvania. Again, freedom of speech, sure, but let's look to the context. The defendant's acting attorney general and acting deputy attorney general had explained to him that that was false. So if he comes in and says, well, whatever I was saying was the truth, these guys told you it wasn't the truth. Also, if he said, well, I can say whatever I want, I'm like, you can, but again, what happened because of what you were saying? And could we have predicted that this would have incited illegal actions? And that, of course, would be the Brandenburg test. So also we have to note when these and where these comments were made. They were made right before an official government proceeding in a place where there were a lot of people who seemed frustrated with the situation. So are we looking at incitement? That's a good question. I'm not saying he is or he isn't. I'm just saying these are questions we can ask. Yeah, and again, too, what your role is as the president. I mean, I don't think you can... I think an interesting clip that I've seen going around quite a bit was a clip where President Obama, and this was years ago, he had made a comment on... I don't remember what source it was, but he was at the Obama Foundation and he made a comment saying, I'm Kenyan. I was born in Kenya, or something to that effect. And then the next thing he said was, I'm just kidding. Everybody laughs, right? But if you cut that audio right after his comment, right, you can kind of manipulate that into what you want. So I think that's an important thing to know. Like, I can say whatever I want, but if I'm president of the United States, what I'm saying can kind of be an important moment. The edit is the manipulation. Exactly. Or yelling fire in a crowded room, right? We've got clear and present danger issues. Absolutely. Again, you're saying the other guy's word is the truth, and it was not right. 10,000... It was not. It wasn't. And we had, legitimate people who were in charge of that information, backing that up. All right. Now we've got, we've got the acting attorney general and acting deputy attorney general. Now there's another question. Are they not credible? Are they not credible? So when they're testifying saying, well, we told him that this wasn't true, is the jury going to believe these two people? Are they credible or not? That's something that we have to take into consideration with a jury. But then we would ask, why wouldn't we trust the attorney general and the acting deputy attorney general? Why wouldn't we believe what they're saying? And you look to see, well, who's asking that question? Who's asking, let's not believe them? Who's saying these guys are not credible? And why would they say that? They're not credible. They're political. Okay, galvanized. Why are they political? Right? Because it was the defendant. They're Republican appointees, and they've taken oaths. So why are they political? And political in what way? So that's the question. Are they? Is this a Democratic political thing? Are they not credible because they've been paid for by the Democrats? I mean, and that's the question. I don't get it. How are they political as an attorney general and an acting deputy attorney general? Like that's a valid question. I mean, why are they political? So, who's saying they're not credible? And why would they be saying they're not credible? What would they gain from that? So those are valid questions to ask and questions to ask the jury. So next we go down. The defendant said that there had been a suspicious vote dump in Detroit, Michigan. Again, you can say whatever you want, although if you're president, it does have a different meaning, perhaps. Let's see. Right. This is being, my lives all get recorded, and I do put them up on my Tube of You channel, and it's of my same name if you're interested in kind of dissecting and going through it, and also leaving comments too. I am always interested to learn more, and if people have comments or want to add things and can't get them out during the live, please feel free to add them on below so we can kind of continue the conversation. That's really what I'm hoping to do here, is just to have this conversation. Oh, good. I'm glad. All right, so here we go. We've got the statement. Now we've got the defendant's attorney general. Again, are we questioning the attorney general's credibility? Had explained to the defendant that this was false. And the defendant's allies in the Michigan state legislature, again, we've got the Speaker of the House of Representatives and Majority Leader of the Senate, had publicly announced that there was no evidence of substantial fraud in the state. So let's just take a moment and pause for Michigan, okay? I mean, I think we could all stand to pause for Michigan. But the Attorney General said there's no fraud. The Speaker of the House of Representatives and the Majority Leader in the Senate in Michigan said there was no fraud. So, do we not believe the Attorney General? Fine. Maybe he's political. Okay. What about the Speaker of the House of Representatives in Michigan, the Majority Leader of the Senate in Michigan? Wouldn't they have a significant interest in having their election be done correctly? And if there was fraud, wouldn't they want to prove that? Wouldn't they want to investigate that? The Speaker and the Majority Leader would have a significant interest in showing that there was fraud in the state in order to clean up their jurisdiction, is what I would assume. But, so now the question is, we don't believe the Attorney General, we don't believe the Speaker of the House of Representatives and the Majority Leader of the Senate, and then why not? Why wouldn't we believe them? Why are they not credible? Right, exactly. I mean, they have a responsibility to their people. This is their jurisdiction. This is their house. And if there's a mess, if there's fraud in their state, they're going to want to go in and take care of it. Right. Who would be credible if not the Speaker of the House of Representatives for the state where the fraud's being questioned and the Majority Leader of the Senate there? Who would be credible if not for these people? That is an excellent question. All right, next, the defendant claimed that there had been tens of thousands of double votes and other fraud in Nevada. The Nevada Secretary of State had previously rebutted the defendant's fraud claims by publicly posting a facts versus myths document. Now, this, of course, can be put into court along with the testimony here, the document explaining that Nevada judges had reviewed and rejected them. So, all right, let's take a look here. We've got Nevada judges and the Nevada Supreme Court. So now we're not even talking about political people, right? Okay, so the Secretary of State, who's in charge of the votes in every state, taking care of the elections, let's just say for some reason we don't believe them because it's political. So now we've got Nevada judges and the Nevada Supreme Court. So let's just look at Nevada. So Nevada is saying there's no fraud claims. There's no fraud that has happened. And that's the Supreme Court that's saying that. So again, do we have credibility issues with the judges and the courts in Nevada? Because if we do, then that's a bigger issue than some bad votes that were going on here. They think that they were paid off. All kinds of people were being paid and then blowing money and votes not counted. That would be, again, I pose the question then, if we go through that analysis, the question becomes, how much money do you have to pay the Supreme Court justices that sit on the Nevada Supreme Court to put false decisions out? How much would it take? I mean, what would it take for a Supreme Court justice to completely throw away their entire career for some cases on fraudulent voting? Yeah. I mean, what would it take? And is it worth it? Is it worth it? Yeah. I mean, would it take a lot of money? Would there be, what kind of money would be involved in that? A bottle of whiskey. Now, come on. Might take a couple bottles, or blackmail for the entire Nevada Supreme Court. Ask Clarence Thomas. He positioned himself early and well. So, I'm not sure he's a good example. He's a bit of an anomaly, that one. But yeah, I mean, I cannot imagine all of the judges that were involved in all of these decisions rejecting all of the claims of fraudulent votes, and the Nevada Supreme Court, what they got together somehow in order to try to say that there was no fraud when there actually was fraud, which would be their job to determine because of some reason. I'm not sure what that reason would be. And to what ends? What does the Nevada Supreme Court gain by saying there was no fraud? What do they have to gain for that? Just money? I mean, is that it? I'm just wondering, because they drink the Kool-Aid. I mean, I don't know. That'd be a lot of Kool-Aid. Hypnotized like the Halloween movie. Maybe, I mean, come on. If we're really breaking this down, we're going line by line here, and we're looking at this evidence, and people are saying, nope, there were fraudulent votes in Nevada. Like, the Nevada Supreme Court says there was not. So what do you need in order to be comfortable saying there was no fraud in Nevada on the election? What would it take? Not the Secretary of State, not the Supreme Court. Who would have to come out and say there was no fraud? I mean, that's the question. If it's not the Supreme Court, who would it be? So I think we're good for Nevada. I think Nevada's solid. I mean, to me, when your courts are pulled in, you're pretty solid. But let's go next into Arizona. The defendants said that more than 30,000 non-citizens had voted in Arizona. The defendant's own campaign manager, so his own campaign manager dude, his buddy, had explained to him that such claims were false. And the Speaker of the Arizona House, again, we have another major player here, Speaker of the Arizona House of Representatives, who had supported the defendant in the election, had issued a public statement. There was no evidence of substantial fraud in Arizona. So again, we have a major person here involved with the state of Arizona saying that there was no fraud. Again, so yeah, his campaign manager, that's like his person, his his dude, that's his fella. And he's saying, nope, that didn't happen. And so now, is his campaign manager not credible? Okay, the Speaker of the Arizona House of Representatives is not credible. And why are they not credible? Because of their past behavior? Because of something that they did that was wrong? Do they have situations where there's been fraud or deceit? Do we have any evidence of that whatsoever? No. I mean, we don't have any. That's a rhetorical question. We don't have any evidence of that. Could we in the future? I don't know. Anything's possible. But I'm just saying, again, when we go line by line and state by state here, there are so many people that we have to discredit and completely ruin their careers for the sake of, 30,000 non-citizens, or for this idea that there had been some voter fraud. So, all these judges are losing their careers and their lives and potentially going to prison for perjury, which would happen for lying to a grand jury. Why are you saying they aren't credible? I'm asking that question for the people who are saying you don't have any evidence. The evidence is, the testimony of these multiple witnesses. And in order to, dissuade or disavow that evidence, to discredit it, we would have to say whoever's testifying isn't credible in order for that evidence to be excluded or for the jury to not believe it. So I'm using it, just to ask these questions of like, okay, if you don't want to believe this as true, if this is false, if these facts are false, then that means that the people testifying to the facts are not credible. Oh, absolutely. Yep, exactly. So, those are the kinds of questions that you have to put out there when you're saying, the evidence isn't there. Like, well, if you discount every single person testifying, then perhaps. All right, so Nevada's solid. Michigan's looking pretty good. Arizona's okay. We got a campaign manager who's his friend and the Speaker of the House again. And then last, we've got the defendant asserted the voting machines in various contested states had switched votes from the defendant to Biden. So this here, as we saw before, statements like this, when you are picking out a particular product and saying the product is not functioning properly, you have to be careful about that. That kind of speech isn't protected. If you are saying bad things against a product and people start doubting that product and that business suffers, there could be issues. So that's kind of a thing. So this particular statement doesn't really even fall under freedom of speech because it's not accurate information about a particular product. The defendant's attorney general, acting attorney general, and acting deputy attorney general all had explained to him that this was false, and numerous recounts and audits had confirmed the accuracy of the voting machines. So now we've got 3 of his people here along with the machines themselves. So that, I would say, this is kind of that first part where you're like, you kind of can't say bad things about products if it's not true. And that's what's happening here. So that's kind of a little different duck when we're talking about all of these different people. Yes. So that kind of takes us then through the different pieces of evidence when we're trying to figure out, again, what the truth is. Trying to find the truth. We're on a hunt. That's what our juries are looking for. Our juries are our fact finders, hunting for the truth and as we go through this. So, yeah, it's a product. We've got products liability issues whenever, you put out false information about a product and it hurts the business. You can get sued for that. Yep. Yeah, it is. Now, juries rule on guts, not fact. They rule on both. We definitely, our jurors are humans, but they also, when they sit down and they take that oath, they look and they have to figure it out. So is this helpful for people? Do you want me to continue to kind of go on and go through this evidence a little bit? Has it been helpful giving you some ideas on how we go about proving what we do here? Yes. Okay. Yes. Helpful. Okay, good. I will go ahead. Okay. I'll go ahead and continue on then. Good. Glad to hear it. Thank you so much. Just checking in. Just wanted to make sure. Sometimes it's hard to gauge when I don't see people in front of me. So, all right. Okay. Okay. All right, let's go to this next batch. Let's go through our states. Oh, excellent. All right, we'll do. And again, we're just talking about different ideas. We're talking about different ways evidence can be presented, different questions that can be called in when it comes to different pieces of evidence. So that's really our goal tonight, is how we figure out how to determine the truth when we are in the legal field. So Let's go to Arizona. We'll start with Arizona. And this is the facts that were given to the grand jury. So we've got the defendant and co-conspirator 1 falsely asserted, among other things, that a substantial number of non-citizens, non-residents, and dead people had voted fraudulently in Arizona. The Arizona House Speaker asked co-conspirator 1 for evidence of the claims. Again, this would all be testified to, which co-conspirator 1 did not have but claimed he would provide. Co-conspirator number 1 never did so. So now we've got criminal actions in this conspiracy claim regarding co-conspirator 1. And, you may say, well, co-conspirator 1 can say that there are falsely asserted or can falsely assert information. But when you're calling into question the election results and you're claiming that, dead people had voted fraudulently and you have no evidence to back that up, we're kind of in a difficult situation, because now we're making an unsubstantiated claim of fraud. So he must be, in order to say dead people voted, the inference would be somebody screwed up and allowed all these dead people to vote. And so that accusation now has consequences, because the people in charge of making sure that the election was legitimate are being called into question, because he's saying all of these dead people voted. Now, the Arizona House Speaker is saying, where's the evidence? He doesn't have any. So he's making accusations against this election process, which is, a problem. When you are trying to make claims of fraud like that, it can be a problem, and it leads to a lot of other things. Again, we've got context here. He confessed that he lied. Okay, interesting. Yes, it really is, Scooter. You're absolutely right. The testimony from the hearing on day 4, yes. I found day 4 to be very helpful. And I found the very last day of testimony to also be very, very interesting. A lot of information was given out. Yeah, the workers would suspect it. Again, because we're not just putting this into an abyss. We're not just saying, I think a whole bunch of dead people voted. For that to happen, there would have been so many people committing crimes in order for that to happen that there would have been mass prosecutions going on. So, recapping. Yes, I'm just kind of going through the different pieces of evidence that were presented in the indictment and kind of explaining, what kind of questions we would want to ask in order to figure out what's true and what's not true. So, yes. Yeah, it is. So let's go to the next piece. The defendant and co-conspirator 1 asked the Arizona House Speaker to call the legislature into session to hold a hearing based on their claims of election fraud. So can you ask the House Speaker to call the legislature into session? Sure. You can ask them to do that. There's nothing wrong with that. The Arizona House Speaker refused, stating that doing so would require a 2/3 votes of its members, and he would not allow it without actual evidence of fraud. Okay, so we have this evidence showing that they're asking for the legislature to be pulled in, and the House Speaker said, you know what, there's no evidence. There's no reason to do that. So again, the inference is the House Speaker told them there was no evidence of fraud, and they weren't going to hold a session. So now we've got more knowledge when it comes to that intent. Well, he really thought that there was fraud. Well, now we've got the Arizona House Speaker explaining we're not calling a session. There's no evidence. So he cannot claim, I had no idea there was no evidence. Like, well, hold on. Somebody told you there wasn't. And in fact, it was so important, they didn't call in another session because of it. Again, these are inferences that can be drawn from the situation. The defendant and co-conspirator 1 asked the Arizona House Speaker to use the legislature to circumvent the process by which legitimate electors would be ascertained for Biden based on the popular vote, and replace those electors with a new slate for the defendant. Now, that is a blatant issue of interrupting a government proceeding. That's just, textbook. The Arizona House Speaker refused, responding that the suggestion was beyond anything he had ever heard and thought of as something within his authority. And that again goes to the credibility of the Arizona House Speaker. He was frustrated and upset with the request, and he'll be able to speak to that when he's testifying. Like, I couldn't believe that they asked me to do this. And of course I said no, because I couldn't do that. So, yes, the disenfranchising of millions of voters, it would definitely go to that as well. And it shows to the extent that they were willing to go in order to kind of go forward with this interruption of a proper procedure for having the legitimate electors involved. So it goes again to that official proceeding on January 6th. So that's Arizona. Let's flip over to, this is the public statement. Again, that's not, it's not evidence here. We've got a public statement. This is, if you want to know what political speech is, you've got it right here. You're fine. But let's move on to Georgia. So we've got a lot of interesting bits of evidence coming out of Georgia. And again, we're talking about this question of people saying, well, there's no evidence. So, that's what we're doing. We're going through just this evidence of probable cause. Is it proof beyond a reasonable doubt? Absolutely not. But we are going through this evidence of probable cause and determining, do we really have evidence of probable cause? Like, well, fine, let's look at it then. All right, here we go. An agent of the defendant and co-conspirator 1 falsely claimed that more than 10,000 dead people voted in Georgia. Again, that claim is making the implication then that somebody screwed up the election to the point where 10,000 dead people voted. All right, so who was involved in that? So that's an accusation again that could lead to some problems for the people that were involved in the process. Like, hey, you screwed up. That afternoon, a senior advisor to the defendant, so here's this character as well, senior advisor, told the defendant's chief of staff through text messages, just FYI, the campaign lawyer and his team verified that the 10K plus supposed dead people voting in Georgia is not accurate. Now, this is a specific writing that can be shown to the jury as well. We would have to have this guy come in as a witness and say, is this the text message you received? Yes, it is. And what was in your text message? It verified that 10K supposed dead people was not accurate. And also, it alleged in co-conspirator 1's hearing today, now we're pulling in another illegal action when you're testifying in front of a congressional, and I guess it's not congressional, but a state hearing. The kind of information that you're giving to the Georgia legislature, and if that information is false, is that illegal? Well, does Georgia have a statute saying that you need to be truthful? That's a good question. I don't know. I don't know Georgia's law. But it sounds like there may be some questions coming out in, this week perhaps. So, yes. Oh, what new stuff? Have to be more specific. There's a lot going on right now. So there's valid questions going on here. Yes. No. Yeah. The big lie. The big lie's fine, according to Trump v. CNN. That's fine. I mean, again, there's a lot of, that's pretty general terms here. Yes. I'm reading through the DC Indictment, and we're going through different pieces of evidence that was set out in the DC Indictment. The paragraph you had at the beginning, this paragraph here, is that what you're talking about? The comments are kind of going quick here, so I'm really sorry about that. What happened to the new stuff? I'm not really sure what you're saying. Sorry about that. It's tough for me to kind of catch everyone here as I'm going through this. They did. Then the Democrat that lost her congressional run and claimed it was stolen would be, what if they did, which Democrat who claimed it was stolen? I don't have any knowledge of that. The papers. Okay, at the beginning, you had before the recap. I've just been going through the indictment tonight, so any of the papers before were just previous pages going through different levels of evidence is what I've been going through. Sometimes I will put in new information from DC, but I've not brought that up yet in this live. I'm just kind of working through the evidence. Oh, sure. Yep. Yep. Yep, sorry, Renee. Sorry about that. It's not quite as, I don't have any brand new things as of yet. There was a motion filed, but it doesn't look that groundbreaking. All right, so, right, we've got the senior advisor clarifying that he believed the actual number was 12. So, again, he would testify to that. Like, was there 10,000 dead people? No. No, it was 12. Like, that's relatively common, actually. Ground baking, too. I know, I've got cake on my mind. I'm always about the cake. But yes, yeah, and that happens. I mean, that can just, we've got clerical errors and technical problems that come in. That's always been an issue. And if you've ever worked in the election, you would know that. You may not know that the number would be like this, but testimony can be easily perjured. True. But one of the things that we're talking about is hundreds of witnesses here. So for hundreds of people to come in and perjure themselves and look at 5 to 10 years federal prison, that's asking a lot of those people. I think it really is asking a lot. All right, another agent of the defendant in co-conspirator 1 playing a misleading excerpt of a video recording of ballot counting at State Farm Arena in Atlanta and insinuating that it showed election workers counting suitcases of illegal ballots. Now, if anyone remembers that period of time, the suitcases were actually shown to be legitimate ballot boxes. So the way that this video was presented, what they're saying in the indictment here is they're saying it's leading to this idea of misleading the Georgia State Senate. And again, this is going to be its own kind of criminal investigation within the state of Georgia. Because of the extent of the misleading of a legislative body in Georgia. Co-conspirator 2 encouraged the legislators to decertify the state's legitimate electors based on false allegations of election fraud. So let's pause for a moment with co-conspirator 2, because if we're encouraging the legislatures to decertify, does that mean then that the proceeding on January 6th would have a problem? Because that's where we take the step then into the criminal elements required for that charge of interrupting or obstructing a government proceeding. Because co-conspirator 2 is asking the state to decertify electors that are supposed to be cast during the proceeding on January 6th. So that's where this evidence comes in. Again, is to say, hey, we're asking you to mess around with the electors, and by messing around with the electors at the state level, it will have a negative impact on the January 6th proceeding. Yeah, it all ties back to the January 6th proceeding. Yes. All right, so that's Georgia, and Georgia's got its own set of situations going on there with that particular set of facts, which they'll be handling in their own courts. Oh, you're welcome. You're welcome. I'm happy to. Again, this is what I do for fun. Is that makes me a bit of a dork, but I'm okay. I'm okay being a dork at this point. All right, let's move on here to this next piece out of Georgia. We've got some important pieces that came in as well. So the defendant raised allegations regarding the State Farm Arena video and repeatedly disparaged one of the same election workers. And I think we've talked about that a little bit before, that co-conspirator 1 had maligned on December 10th. Now, again, pause for that First Amendment freedom of speech moment. You cannot use your freedom of speech to malign or defame another person. That is incorrect, illegal. Civilly as well, using her name almost 20 times and falsely referring to her as a professional vote scammer and hustler. Again, pausing. We're all dorks. Oh, thank goodness. I found my people. Thank goodness. So, all right, let's pause here. This is not political speech, is it? This is not Dorks Unite. This is not just someone saying, oh, I've got a political point of view. No, this is someone who is saying a particular person committed these bad acts and name calling. So this is shifted up a little bit Sure. I'm trying to keep everything in. Here we go. Let me know. Yeah, no, that's not free speech. You cannot have free speech when you are defaming another person. Defamation is not covered by free speech. It's just not. That's not how it works. And this is a classic example of making a statement in public that disparages another person. Yep. I think she did sue. I think somebody said she did sue. I don't have a follow-up on that, so I can't speak to it. But yeah, I mean, there were some significant negative repercussions that occurred here. In response, the Georgia Secretary of State refuted this. You're talking about State Farm video. And I think it's extremely unfortunate that co-conspirator 1 or his people, they sliced and diced that video and took it out of context. That's some pretty harsh language there. When the Georgia Secretary of State then offered a link to a video that would disprove co-conspirator 1's claims, the defendant responded, I don't care about the link. That goes to intent. All right, so when we're asking what was his intent, he truly believed that this was going on. It's like, well, wait a minute. They offered evidence to disprove it, and he said he didn't care about the link. I don't need it. Georgia Secretary of State, I have a much better link. So again, that language is very vague, so we're not going to be able to specifically cite a moment here, but we can also say that he was offered some information that would clear it up, and he said he didn't want it, and that's fine. He didn't have to look at it, but it goes again to intent. The best links, all the best links, yes. Yeah, I mean, he certainly didn't have to. But when we're saying like he had no idea, now we can pull in a testimony from a witness that said, well, I tried to tell him. So he would have an idea, and he said he didn't want it, which is fine. Which is absolutely fine. All right, so next we've got the defendant asked about rumors that paper ballots cast in the election were being destroyed, and the Georgia Secretary of State's counsel explained to him that the claim had been investigated and was not true. So now he's got knowledge again. The Georgia Secretary's State counsel, and again, keep that in mind, we're at a point now where the Secretary of State's lawyer is now involved and explaining things to him. The defendant claimed that 5,000 dead people voted in Georgia, causing the Georgia Secretary of State to respond, quote, well, Mr. President, the challenge that you have is the data you have is wrong. The actual number were two people that were dead that voted. And so your information is wrong. That was 2. And if you can imagine the testimony when you pull in this person to actually say those words out loud, it's probably, the jury will have to assess that credibility and the records that were kept on it. So next we've got the defendant claimed that thousands of out-of-state voters had cast ballots in the Georgia election, which the Georgia Secretary of State's counsel refuted. Again, Georgia's Secretary of State's lawyer is now talking to the defendant. We've been going through each of those as well, and those numbers that we got, the defendant's counsel was just saying they're not accurate. Every one we've been through are people that lived in Georgia, moved to a different state, but then moved back to Georgia legitimately. They moved back in years ago. This was not like something just before the election. Again, these kinds of statements and discussion go to that intent level that we're looking for. So when we have this question, he didn't know, he had no idea, he didn't know. That intent element can be testified to by the Georgia Secretary of State's counsel. I told him. So there you go. This is illegal advice. Oh, no, it's not. It certainly is not advice in any way, but we are learning. We're in a learning community. You can prove intent. Oh, I assure you, you most certainly can prove intent. That's one of our key elements to our corpus delicti. We have to prove intent every time we go to trial. Yep. All right, next, the response to multiple other of the defendant's allegations to the Georgia Secretary of State's counsel told the defendant that the Georgia Bureau of Investigation was examining all such claims and finding no merit to them. Now we've got not only the counsel for the Secretary of State, but now we've got the Georgia Bureau of Investigation. They can all be called in to testify as well. that would be absolutely fine. How am I supposed to prosecute obstruction? This isn't. No, I know, right? How will you? Am I snarky? I've got a bit of sass to me, trying to be respectful. But yeah, usually I get to a point my sass is unable to not come out. Yes, accusations are free speech to some degree, unless it harms another person, and then it is not. And in fact, our common law sets out accusations of crimes as one of the original forms of defamation they can be sued over. And in fact, in the old days, you could be very unceremoniously taken away in an unkindly manner from which you can never return just for making the accusation of a crime. I'm not saying it's right. I'm just saying that's what they did. Here we go. Oh, my goodness. All right. The defendant said that he needed to find 11,780 votes. So you don't want that. That's not good. I think we all know that. I think we can all agree that that's not good. That's not good here. And insinuated that the Georgia Secretary of State and his counsel could be subject to criminal prosecution if they failed to find election fraud as he demanded. That's, also not so good, stating, quote, and if you are going to find that there are, which is totally illegal, it's more illegal for you than it is for them because you know what they did and you're not reporting it. That's a criminal, that's a criminal offense. And, you can't let that happen. That's a big risk to you and to the Georgia Secretary of State's counsel, your lawyer. All right, let's break that apart. How is this political speech? Tell me how this is political speech. I will accept what you have to say. But I won't accept it as true because this person is talking to the Secretary of State, asking for a specific number of votes, and his counsel and him are going to be subject to criminal prosecution if they don't find election fraud. Now, we've got other people involved that have been fired. We have the CISA guy that was fired. We've got the Attorney General that's like, if you don't find any fraud, then I'm going to replace you with this new guy. I mean, this is something that's consistently being done over and over and over again. And so, to say, well, he's just talking, political speech. I'm like, well, is he saying political speech to every single person that he's saying is going to lose their job or face some kind of sanctions? Because we've got multiple people now. We've got handfuls of people that he's saying, if you don't find fraud, you're going to lose your job, you're going to have criminal sanctions and so on. And I'm not sure how that can be put into the box of political speech so that freedom of speech is protected. Because when we have these kinds of implications of criminal charges, I mean, I don't know. Is it proof beyond a reasonable doubt? I don't know. That, he wasn't making a threat. He was just talking. Maybe. But how would we prove that he was just talking? Who would we call to testify to the stand to say he was just joking around? Who would that have to be in order to testify? It would have to be probably the defendant. He would have to be called up to the stand, ask specifically about this statement, and testify, I was just joking around. I'm not sure how else you would prove this statement was only political speech, and that's what it was intended for. Yes, I don't know that he would testify. I'm just saying, as far as evidence to prove the intent behind his own language, I'm not sure who could testify. Now we're getting into have his best friend testify? Well, he told me afterwards that he was just kidding around. Now that kind of hearsay is not allowed in court. That actually is a hearsay violation. So he himself would need to go up and say, look, I was just kidding around. we were just, what's the phrase we like to use? We were just locker room talking here. That's all we had going on. This is no big deal whatsoever. I mean, I kid because it's getting late and I'm being silly, but I mean, come on. We're going to have to have intent shown by some means. And the way to burn, that wasn't very nice of me. That wasn't very nice. That was that was unkind. It was recorded. Yes, unkind. But I mean, shop talk. Okay. Yes, shop talk. Exactly. Right. I mean, I'm seriously, what's he going to say? I'm just joking. But I mean, when he comes in and says things like, that's a big risk to you and the Georgia Secretary of State's counsel, your lawyer, I mean, how are you supposed to take that? Like a risk to what? Like, my credibility or our friendship? I mean, what's the risk? We're going to need to show intent here. Yes, an affidavit is not something that would be able to be admitted into court. We would have to have testimony specifically to that. And I'll tell you why. If he was to write out in an affidavit, I swear that I said this sentence because I intended it as just kind of joking around, political free speech. If he wrote that into an affidavit, who would be called as the witness to get that piece of evidence in front of the jury? Because that's what you need in order to present evidence. You have to have someone testifying. So who would it be? I mean, the cop that he is writing the affidavit with, it's like, oh yeah, he came in the other day and wrote this down. I mean, I don't know how that affidavit would come into court. That's why things like affidavits and like that cannot just come in. We've got to have a witness testifying and an appropriate, relevant reason for that affidavit to come in. So that would be the big. Have to be able to cross-examine. Yes. Oh, excellent point, RRX68. Absolutely. And cross-examination is so important and something that is not presented to a grand jury. That's why we've only got probable cause here. So we're kind of talking about some of those things they could ask on cross-examination, some of those kinds of issues. But, you need to be subject to cross-examination, and you cannot cross-examine an affidavit. All right, so that's this piece when we're talking about Georgia. And again, there's a lot going on in Georgia. There's a lot going on there. Now, this is just a statement that was given, so I'm not going to spend much time on that. Let's look around here for some more evidence. We don't really have much from Michigan. Here's Pennsylvania. I mean, we've got evidence, don't get me wrong, but we don't have evidence I can really analyze for you is what I'm trying to say. We've got Wisconsin. Let's just take a look at Wisconsin because the courts were so outspoken in Wisconsin. And by outspoken, I mean they listened to the case and then made a decision. So let's take a look here for Wisconsin. We've got a recount in Wisconsin that defendant's campaign manager had petitioned and paid for, did not change the election result, and in fact increased the defendant's margin of defeat. December 14th, the Wisconsin Supreme Court rejected an election challenge by the campaign. One justice wrote, quote, "Nothing in this case casts any legitimate doubt that the people of Wisconsin lawfully chose Vice President Biden and Senator Harris to be the next leaders of our great country," end quote. And this is what we were talking about before when we were saying, when we're looking to the credibility of these witnesses, when people are saying there's no evidence. Well, now we've got the Wisconsin Supreme Court. We had the Nevada Supreme Court. Now we've got Wisconsin Supreme Court. And are we going to come in and question the credibility of the court's decision in Wisconsin? That's kind of what the question is. They never viewed the evidence. Do you mean the Wisconsin Supreme Court didn't view the evidence? Because the Supreme Court's an appellate court. So they're looking to the laws to see if any of the laws had been ruined. But I have not read the Wisconsin Supreme Court decisions. Yep. And they should definitely question the Wisconsin Supreme Court. All right, fair enough. Let's call them in then to testify. Let's call them in. And if we're trying to get something like a Supreme Court decision into court in front of the jury, how do we do that? And we have this question of relevance. What's relevant? And in order to determine relevance, we look to our rules. When we look to our rules, we find relevance evidence is relevant if it has a tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. So what is the point here? What's the reason why we would need the Wisconsin Supreme Court to testify? Wisconsin Supreme Court said there was no fraud. So they would be testifying that there was no fraud. So now the question is, was the legal question that there was fraud in the election? Or was the legal question that the statements that were made on January 6th obstructed the government proceeding? And if that's the question, do we need the Wisconsin Supreme Court's justice to come in and testify that they didn't find fraud in the case? That would be the way that we would determine whether it was relevant or not. So I would say, I'm not sure. I mean, we're not really challenging, maybe, we're not really challenging the legitimacy of the election. What we're challenging are the words that were used in order to obstruct the proceeding that day. So was the words and the situation and the electors, all of those things were all a way to obstruct the proceeding is what we're asking. Why would the Wisconsin Supreme Court declare zero fraud if it wasn't accurate? Exactly, Deanna. I mean, that's exactly the question. Why would they risk their careers just like Nevada? Why would they do that to say that there's no fraud? Now, when we're establishing probable cause, again, I can see why they're listing here. Well, not only was it the defendant's campaign petitioned and paid for it, and there was defeat here, but the Supreme Court said there was no fraud, and here's another quote. So we have this piece of evidence showing, again, there was no fraud, and that could go to the intent level. But yeah, why would they? Why would they lie? Why would they make a decision that would harm their careers and their lives? I mean, and it'd totally ruin their lives. It'd be a miscarriage of justice. Can you go over what can and can't go in as far as hearsay? Sure. Oh, sure. Let's talk about that. So let me finish up here. We've got the Wisconsin Supreme Court rejecting election challenges. So again, if there's a question, well, I really believed in Wisconsin there was fraud. Well, the Wisconsin Supreme Court held in their cases that there was no fraud. So now we've got this element of intent that's being discussed again. So let me talk for a minute here about hearsay. Hearsay is, it's a curious animal because we all struggle with it as attorneys. All of us do. But it's one of those things where hearsay is defined under Rule 801. And we have statements that are not hearsay. We have statements that are non-hearsay. And we have statements that are hearsay but are exceptions. When the courts have found credibility in a statement, they will allow it in under an exception. That's why we have so many. But a statement that it means a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. The declarant means the person who made the statement, and that person will come into court to testify typically. But hearsay itself means a statement that the declarant does not make while testifying at the current trial, so it's outside of court, and a party offers it in evidence to prove the truth of the matter asserted in the statement. So it has to be with regards to what's going on in the situation. So probably one of the best examples of hearsay is someone had taken some of their grandmother's car, and grandmother called it in and said their car was stolen. Meanwhile, the kid said, well, she let me use it. I was just borrowing it, and happened to leave it in a parking lot of a building of ill repute. Now, somebody testified, yes, we found the vehicle, and the question was whether or not he had permission. The question's not, where was it parked? The question was, did he have permission? So the person testifying was, yes, we found the vehicle, and it was in the parking lot of a building of ill repute. Now, what could happen then for the jury to hear the kind of place where the vehicle was? So that kind of information would not be relevant, and we would not pull it in. And we're also not using it to prove the truth of the matter asserted, which meant, are we using it to prove that he got permission? No. So that's really a quick and dirty explanation of hearsay. Super quick and dirty. But we also have, again, statements that are not hearsay. Here we've got prior statements, an opposing party statements, which we really have a lot. Statements offered against an opposing party. And then again, when we go into the exceptions, so we've got 803 exceptions, and there's just dozens of them. So if it's an excited utterance, if it's a recorded recollection, a statement made for medical diagnosis, those are all allowed. Public records, family records, certificates of marriage, baptism, similar ceremonies. If you think about it, a marriage certificate technically is hearsay. It's, a statement made outside of court, and if you're trying to prove that there was a marriage, you can bring it in under one of the exceptions. Statements and documents affecting an interest in property, statements in ancient documents, and according to this, an ancient document is something prepared before January 1st of 1998. So that document's now ancient, the rules of hearsay. Treatises, periodicals, market reports, reputation regarding character, reputation concerning personal family history, judgments, and so on. Tons of exceptions, and then we also have exceptions when the declarant's unavailable. Now, there's a particular exception that is fascinating. As the dork that I am, I tried to bring this out. Let's see. This is, let me see here. We've got probably a statement a lot of people have heard of, which is called a dying declaration. So a statement that's made under the belief of imminent death. So if you say something and you believe you're about to pass away, that statement can be used in court, even if you don't pass away. And that's what we call the dying declaration. Statements, again, against your interest. And this is one of my favorite pieces here. I call this the mafia exception. And probably is not a very nice way to put this, but if we've got statement offered against a party that wrongfully caused the declarant's unavailability. So if there was a statement involved and somehow one party caused the declarant to be unavailable, then that statement can still be used. So there you go. There's some hearsay, looking at hearsay for you. I'm way past ancient. Yeah, I hear ya. But yeah, so hearsay's got a ton of exceptions. That's really the bottom line, is that hearsay's not admissible, but, there's 27 exceptions, so it could potentially come in depending on what it is. Yes, ancient. I know the ancient one's a bit painful. All right, so let me flip then. We finished out Wisconsin with the Wisconsin Supreme Court. So let me flip back into some more evidence here. I think some of the most damaging evidence that is listed in this indictment that's been used repeatedly are these 3 memos. So I think the hearsay discussion really triggers or tips us into the memorandum discussion, because some people might say this memo would be hearsay. And, oh, Jonathan, is my content horrendous? You can go on. It's okay. I won't be offended if you guys are bored. You can flip on by. That won't bother me one bit. But these pieces, these memorandums are so significant in showing the conspiracy and the fraudulent electors. So they're really essential here. November 18th memo, the Wisconsin memo, advocating because of ongoing recount in Wisconsin, the defendants' electors, they should meet and cast votes on December 14th, the date the ECA required appointed electors to vote, to preserve the alternative of the defendant's Wisconsin elector slate in the event the defendant ultimately prevailed in the state. So who's going to present this memo in court? Who's the one that's going to testify? Oh, thank you. Who's going to testify? Because they're going to need to call somebody in to court, introduce them, put their foundation down in front of that jury, and ask that person about this memo. So whomever wrote this memo could testify. Whoever received the memo could testify. That kind of information would be, please state your name and your title for the record, and Are you familiar with a memo that was circulated on November 18th? Yes, I am. Can you take us through what that memo said? Yes, I can. And then they'll go through the memo and explain that to the jury in order to say what's going on. So all of that evidence could come into trial in front of the jury. Next, we've got the December 6th memorandum, the fraudulent elector memo. And again, this specifically goes into the bad act. And I say the bad act as a translation for actus reus, which we need for charging a crime. Should meet and mimic as best as possible the actions of legitimate Biden electors, and that on January 6th, the vice president should open and count the fraudulent votes, setting up a fake controversy that would derail the proper certification of Biden as president-elect. And that specifically goes to the government function, the proceeding that was occurring on January 6th. And again, it's set out word for word in the memo. And if we get someone on the stand to testify to this, that memo comes in as evidence in front of our trial jury. All right, December 9th memorandum, fraudulent elector instructions. Again, instructions on how the fraudulent electors could mimic legitimate electors in Arizona, Georgia, Michigan, Nevada, Pennsylvania, Wisconsin. Co-conspirator 5 noted that in some states it would be virtually impossible for the fraudulent electors to successfully take the same steps. Now, I think this is important here because this goes to co-conspirator 5's intent. He knew what he was doing was against the rules, and he knew it would not succeed, and he set that information out. So there wasn't this, I really think this is legitimate, we should go forward with our political discussion about issues. But no, he knew that there would be a problem because the legitimate electors, because of the state law requirements and the formal participation needed in the process by state officials or access to official resources. So that again goes to this element of intent for co-conspirator 5. Yes, and hearsay that would be allowed in. I won't go back too far into the hearsay rules. It's a bit dry. Got to keep it hopping here so we can get through. Yes, it is hard to prove intent, but our intent and our act are the two essential elements in any criminal case that we have to prove. Those are essential elements. So, let's see. I want to pull in specific pieces of evidence again, just to kind of keep it clear. So here we go. Here's our next batch of evidence that was put into this grand jury indictment. When do you prove context? I think the whole time you're going to prove context. Typically, we put our strongest witness on first and last, and that's just a typical strategy. Not everybody does that, but we will need our strongest witness to set the stage, and we want to walk our jury through what happened. And so we'll take them through the whole process from beginning to end, and all of that context will be set out at the very beginning. And then once that's all set out, then we'll come back in with additional witnesses to fill in that evidence, to add the exhibits in, and to take everybody through it piece by piece. But that initial witness is going to be the one to really set the stage and give that big picture before we start breaking everything down line by line to our jury. Yeah, the timeline. And it has to be set out in a way that makes it clear so that the jury can follow along. In opening statements, we will set out our roadmap for how the case is going to present. We're going to say, these are the charges, these are the witnesses, this is what they're going to testify to, and at the end, you will have to find guilt beyond a reasonable doubt. I would assume Jack would be at the table. I would absolutely assume that because he has done so much work on this case, and he would have... I think the strategy of this case, he's going to have amazing help with that, but it really is he's the point of contact. He's the one that's really brought all of this up. So in the way, good luck proving intent. It's not easy to prove intent, but we do it in every criminal case that we have, unless it's a strict liability criminal offense. Can we get to RICO? We can't do RICO tonight. I'm not ready for RICO tonight, but I do have it on the schedule. There's overwhelming evidence against him doing the wrong thing to do the crime. You do the child. True. Oh, thank you. You're welcome, Rosie. You're absolutely welcome. Sure. Thanks for the question. Appreciate that. So yeah, he will take everybody through it. The motive is considered the criminal's intent. Now, that's a good point. Our motive, our mens rea, has different levels of intent. Motive is actually a subcategory of intent, technically under the law. So it can be a piece. The motive, like why he did it, is one thing, but the actual intent can be recklessness. It can be knowledgeable. It could be knowingly. There's lots of different kinds of intent levels, and motive is one of those pieces. Yeah, knowledge of the crime is important, but what we're doing when we're going through all of this evidence is we're showing where people have given this knowledge to him. Now, whether he took it in or not, that's something to be determined. That's absolutely a valid thing to ask of our jury to determine if it's valid or not. But there's a lot of evidence every time you open. Yes, there really is. He looked a little tired. I thought he looked pretty good, really, as a prosecutor. I think he's probably got a decent makeup team working for him. Because it drains the life out of you. In the deeply rooted history of the Presidential Records Act and amendments. Yes, and I've gone through the Presidential Records Act. I have posts on it. I've actually read through that act and done posts. Did the judge respond to defense's motions yesterday? She did. She said that you guys need to come together and pick a couple days out. And then it did look like we've updated the docket since then. I sound tired tonight. Well, drink some water. I may need to. We're coming down. We're turning a corner here, so. Yes, they've set the hearing for then, but we've got the superseding indictment arraignment coming up too. So there's that. Have I done the Florida indictment? I did. I have done the Florida indictment, but with the superseding indictment arraignment that's coming up, I could go through that again if people are interested. It has been a while. It's been, that came out, 2 weeks ago? So it's been a while, but, oh, thank you. Thank you so much. Okay. Yeah, I've gone through the superseding indictment. I've done some posts on it, but I probably could go through it one more time. I was just looking through it today, and we do have a couple of interesting pieces that have come out recently on the docket, so I may go ahead and add it. What's the superseding indictment? The superseding indictment was added just a couple weeks ago to add a third defendant and a couple more counts to everybody. So that was just added. Yeah, the Florida one. Yep. Oh, mock trial student pre-law. Oh, good. Good for you. Oh, I'm so glad I can help. Yes, and I do have a YouTube or a Tube of You channel where I, all of my lives are recorded and I do upload them. So for anyone who wants to just kind of skip through and go through it, you're welcome to do that. So please do Florida. Okay, well, I will do that. I know, again, we've got that superseding indictment arraignment coming up. So let me just make a note. I'll probably make a post about it so you've got some idea of when it would be, just to kind of go through it and explain it again one more time. So, but let's go ahead and finish as we're going through again, talking about different ways of proving truth. When we are going into court and having our fact finders, which is our jury, figure out what's credible, what's not credible. So let's take a look. We've got this draft letter that's been raised quite a few times, and it's a bit concerning. So let's take a look at the language. The Justice Department had identified significant concerns that may have impacted the outcome of the election in multiple states. End quote. The Justice Department believed that in Georgia and other states, 2 valid slates of electors had gathered at proper locations on December 14th. Again, we're just going to need to pull these electors in to testify. and that both sets of ballots had been transmitted to Congress. That is, Conspiracy 4's letter sought to advance the defendant's fraudulent elector plan by using the authority of the Justice Department to falsely present the fraudulent electors as a valid alternative to the legitimate electors. So when we're going in and we're asking these questions on what the purpose was behind the letter, how are we going to go forward and prove those things? If we're looking for proof on the intent, are we going to have co-conspirator 4 testify? And if so, are they going to invoke their Fifth Amendment right against self-incrimination, right? So if they're going to invoke the Fifth Amendment, then they're no longer available for testimony. We're going to have to figure out another way to figure out how to get co-conspirator 4's intent of this letter to the jury. So we would have, we would have people testify about what was the context, again, of when did you get the letter and what did you think of the letter, and did you talk to co-conspirator 4? And what did co-conspirator 4 tell you about that? Now, those kinds of statements about co-conspirator 4 could be seen as hearsay, but most likely because they're statements against an interest, they may be allowed in. So that intent will have to come in through those grounds. Now, we're not talking about specific words. We're talking about what the point of the letter was. So we can use inferences. We can use other people who received the letter and kind of figured out what the point was to it as ways to prove to our jury that this is what we had. And then the Justice Department urged the state legislature to convene a special legislative session to create the opportunity to, among other things, choose the fraudulent electors over the legitimate electors. And again, we've got this issue of the fraudulent versus legitimate electors as well. So again, anyone who received this letter or instructions from co-conspirator 4 would be able to testify about the intent and the content of that letter in any of those bits. So now let's take a peek. Again, I'm just pulling out the pieces of evidence. I think the last real batch I want to go through here have to do with the vice president. Because, we did have that initial question of, is the vice president reliable? Is he credible? And that's what the jury has to assess. And what is it about the vice president that would make him not be credible for the grand jury or in front of the trial jury? So let's take a look. On December 25th, when the vice president called the defendant to wish him a Merry Christmas, the defendant quickly turned the conversation to January 6th and his request that the vice president reject electoral votes that day. Again, all of this would have to be testified to by the vice president. He would have to get up on the stand and testify. The vice president pushed back, telling the defendant, as the vice president already had in previous conversations, I don't think I have the authority to change the outcome. Again, this would be an exact piece of hearsay under the exception of present sense impression would be what I would argue. So if there's a hearsay objection, I would say, present sense impression because he had taken notes that occurred at the time. And the timing is key for that. But he would be testifying to all of this. On December 29th, as reflected in the vice president's contemporaneous notes, the defendant falsely told the vice president that the Justice Department was finding major infractions. And the vice president would be testifying to that. Did you take notes that day? Yes, I did. And what did they say? And then he would go through that. Next, on January 1st, the defendant called the vice president and berated him because he had learned that the vice president had opposed a lawsuit seeking a judicial decision that at the certification, the vice president had the authority to reject or return votes to the states under the Constitution. Now, I just want to pause here because we have a phone call between the defendant and the vice president. So those are the only two people involved in this phone call. And we have this phrase, and berated him. So how do we know that the defendant berated the vice president? How do we have evidence there to prove that? How did that language come about? Because it's got a negative connotation to it, that he, was being negative towards the vice president. But how would we possibly know that? Because it's a conversation between two people. And so the fact that this is actually stated within, exactly. This is stated within the indictment, this specific language. Yep. This kind of language. So there must have been evidence to back that up. And that grand jury heard this evidence, heard these words involved in this conversation and the rationale behind it because of the certification denials. Yep, exactly. How do you berate your own vice president you appointed? Yeah, I think it's, that's some pretty harsh language there. The vice president responded that he thought there was no constitutional basis for such authority and that it was improper. In response, the defendant told the vice president, quote, "You're too honest." Now, again, why do we have this quote? Because we must have some way that this has been documented. Yeah, you're too honest part. Because we're in quotes, we must have some kind of documentation that has this direct language in it. Within hours of the conversation, the defendant reminded his supporters to meet in Washington before the certification proceeding, tweeting, "The big protest rally in Washington, D.C. will take place at 11 a.m. on January 6th. Locational details to follow. Stop the steal." Again, all of this would be testified to, and we've got this tweet. So let's talk about that. Do we need to have the defendant in order to get his tweet into the record as evidence? Okay, that's a good question. He's not going to want to sit up there and testify. So how do we get this language then in front of the jury? Who would be our witness? Right, for the tweet. It's public access. Yes, it is. And if it's public access, then who do we have that's going to be testifying? We would just need someone. It's a document on Twitter. Right. Probably one of the best. One of the best people to testify. How about the archivist for the National Archives? Could we call him in? Could we call in the archivist who's in charge of keeping track of all the tweets? I'm not sure the Twitter guy would necessarily be of the credibility level that we're looking for. That would be a business record? Yes. It's in the National Archives. Exactly. It is. Yes. So whoever's in charge of the National Archives, right, or keeping track of presidential information, that's the person that could be called in to testify. So I would like you to go through a tweet that was tweeted out on January 1st. Can you read through it? Sure. And then this is what they would do. They only need to prove it's regular to keep the presidential tweets. Exactly. Yep. Exactly. And any of this information, because he was still president at the time, is all going to be archived in the National Archives. All of that. Yeah. Yep. And the request for the National Guard. Now that's a little bit different when we need to call somebody in to testify. But anytime we've got a tweet like this, when we're saying, the defendant's not going to want to testify, we need to look and see who the person is in charge of keeping that record. And if you think about it, if you put the National Archivist or even, the second or third in command on the stand in front of a jury, what kind of credibility are we going to be dealing with? Now we've got the National Archivist involved with these kinds of statements. So that reliability issue is not really going to be at play, typically, when you have someone like that. Yeah. Yep, exactly. And they can set it up. Yes, every single word. Yes, it's true. All right, so on January 3rd, the defendant again told the vice president that at the certification proceeding, the vice president had the absolute right to reject electoral votes and the ability to overturn the election. That would all be the vice president's testimony. The vice president responded that he had no such authority and that a federal appeals court had rejected the lawsuit, making the claim the previous day. So he would be able to testify to, which federal appeals court are you referring to when you made that notation? And then he could go in and explain that appeals court decision. Well, such and such decided that that was something that I wasn't able to do. So now we've got evidence showing that the vice president knew he couldn't interrupt that proceeding in that way because we have a court ruling that he can talk about. So those pieces are essential as well. Yes. Yeah, he did. All right. So let's pop down. Again, I want to spend a little bit of time here with the vice president because he really is a key character in this situation. We've got direct quotes. All of this, again, has all been public record, and whoever can testify to this, we've got lots of different abilities. He had the authority to send it back. He did not. He absolutely did not have the authority to send that back to the states. He did not. He just didn't. So if you believe that, then that's fine. But I beg you to find a source to support that, like a legitimate legal source. And I don't speak in definitives very often, but he does not. The vice president could not send that back. Yeah. He could not act unilaterally like that in his role. It's just not possible. And those of us who've studied political science or spend much time with the Constitution, we knew that. But it just wasn't something that was commonly known. So I think even asking that question, the fact that it was even brought up and that people immediately didn't realize that it was incorrect, I think shows just how we just do not clarify how our government proceedings work. Yeah, we just didn't clarify it. It just wasn't, unfortunately, people just didn't realize, like, most of us that work in that field were like knee-jerk reaction, this is impossible. But for the general public, they just didn't know. People just didn't know that couldn't happen. Yep. So now we've got more statements here. The vice president challenged co-conspirator 2 on whether the proposal to return the question to the states was defensible. Co-conspirator 2 responded, well, nobody's tested it before. That's true, but there's a lot of things that haven't been tested before. So that's not necessarily a good way to look at it. But the vice president then told the defendant, quote, "Did you hear that? Even your own counsel is not saying I have that authority." So he knew it. He expressed it to the defendant, and the defendant responded, "That's okay. I prefer the other suggestion," which was even more significant, of the vice president rejecting the electors unilaterally. So that even kicked it up another notch. And that kicked it to the next level. So not only are we asking the vice president to send it back to the states, but now we're asking the vice president to completely reject the electorals, which is a completely, it's the definition of obstruction. Right. Yeah. It's not very elegant, the coup here. It doesn't have any of those kinds of elements to it, but it's definitely, there's a lot of pushing of this obstruction of these actual proceedings in order for the votes to be counted, the electors to be counted, all of those things. We needed things to take place, and that's exactly why obstruction was a good charge with this set of facts, with this information. Because that's what we're talking about. We're talking about the proceeding for the electors, the legitimate electors, to be involved, and that proceeding was interrupted. And that's exactly what happened. So, on January 4th, when co-conspirator 2 acknowledged to the defendant's senior advisor that no court would support his proposal, the senior advisor told co-conspirator 2, quote, "You're going to cause riots in the streets." Co-conspirator 2 responded that there had previously been points in the nation's history where violence was necessary to protect the republic. Now, let's pause for a moment here. Why is this important, and why do we need this knowledge? Because we're showing the intent of co-conspirator 2. This co-conspirator 2, whoever it is saying, you know what, we've had violence before, so we might need violence again to protect the republic. that goes to show what level we were at with the disruption of this government proceeding. Right. So with co-conspirators stating, hey, there might be violence, we've got this idea then of this eminent lawless activity that we've been talking about, which is not covered free speech. That level of violence, especially if it's imminently lawless, you're not allowed to have that kind of speech protected. You can be charged. But again, it goes to this intent. What was co-conspirator 2 thinking was going to happen? What was the intent there? After that conversation, the senior advisor notified the defendant that co-conspirator 2 had conceded that his plan was not going to work. So now we've got co-conspirator knowing that his plan's not going to work in this situation. So just one moment, please. I just have been given a signal. Just one moment. Okay, thank you for your patience. All right, here we go. All right, back we go. So, where were we? We've got senior advisor notifying the plan's not going to work. So we do have knowledge in this situation. Now, yeah, I mean, it's just not. I think, we have this idea again that was brought up in the Trump v. CNN case, and I bring it up again because it's a legal document, but that if you say something repeatedly, that somehow people believe it. And I think that can be true when we don't really know how things work properly. So I think that that's kind of a failure on a lot of teaching elements, that people didn't quite understand that. So let's bump down the next one. On the morning of January 5th, the defendant's direction, the vice president's chief of staff and the vice president's counsel met again with co-conspirator 2. Co-conspirator 2 now advocated that the vice president do what the defendant had said he preferred the day before: unilaterally reject electors from the targeted states. That again is huge, and that would disrupt or obstruct that proceeding. Now, this part, again, is this very, very disturbing bit that comes up during this next meeting. Co-conspirator 2 privately acknowledged to the vice president's counsel. So if this is a private discussion with the vice president's own lawyer, now we know who's going to be testifying here, that he hoped to prevent judicial review of his proposal because he understood that it would be unanimously rejected by the Supreme Court. So this speaks again to this question. A lot of people are saying, well, if this case gets in front of the U.S. Supreme Court, they'll take care of it. Meanwhile, the U.S. Supreme Court's already being discussed, and they're already saying there's no way the U.S. Supreme Court's going to agree with this situation. It is big information, because there is this acknowledgement that even the U.S. Supreme Court is not going to support this proposal. And I think acknowledging that moment is important. The vice president's counsel expressed to co-conspirator 2 that following through with the proposal would result in a disastrous situation where the election might have to be decided in the streets, which again is a devastating statement by the vice president's own attorney. So now we get into the different quotes and pieces going on through social media. We've got all of these people on the way. We've got the claim that the vice president's got the power to reject fraudulently chosen electors. So again, who would we have to testify to this statement that was made? We would be able to pull in, the archivist. So again, imagine being the trial jury and having the archivist come in and read tweets that were issued with this language in it. The vice president has the power to reject fraudulently chosen electors, end quote. This was 40 minutes after the defendant's earlier reminder, see you in DC. Again, all this would be testified to by whoever keeps the presidential records. Now we've got 505, Washington's being inundated with people who don't want to see an election victory stolen. Our country has had enough. They won't take it anymore. We hear you and love you from the Oval Office. This can be read directly into the record in front of the jury through whoever they choose to have that would verify the document. And I think, too, there's some level of legitimacy that comes with having the person in charge of archiving the presidential moments testifying. Yes, 5:43 p.m. I will be speaking at the Save America rally tomorrow on the Ellipse at 11 a.m. Eastern. Arrive early. Doors open at 7 a.m. Eastern. Big crowds. Again, this could go to, do we think that there's an imminent lawless action that's going to happen, potentially? So that could happen. Now, the next part here, we've got the vice president's safety that's being alerted, and because the vice president's kind of being pulled in on this. Now, alerted the head of the vice president's Secret Service detail. So now we've got the head of the vice president's Secret Service detail who could testify. Now, imagine having whoever this person is on the stand in front of a jury saying, I was called in to protect the vice president because the chief of staff was concerned for his safety because of what was being said. That would be some pretty significant testimony, I would think, to have someone of that level of credibility. Yep, another witness, exactly. And so again, when they're saying we don't have any evidence, none of this is factually based, well, we've got the vice president's Secret Service detail, the person in charge of that, is called in for protection. And also this note that the defendant knew that the crowd looked angry, so we would just have someone testifying to that as well. The defendant approved and caused the defendant's campaign to issue a public statement that the defendant knew from his meeting with the vice president only hours ago was fake. Quote, the vice president and I are in total agreement that the vice president has the power to act. Someone can come and testify as to that statement as well. So now let's get into what's happening on January 6th. This is really the crucial piece of the evidence that's coming in order to show we have a government proceeding that's being interrupted. So let me break down each piece of this. Now, if you'll just give me 1 second, I need to plug my battery in. I promised myself I wouldn't go so long on my lives, but I think I lied to myself. So just 1 moment, please. Okay, and we're back. Hopefully I'm back in frame okay. Just let me know. And then we will walk through the evidence we've got on January 6th. Okay, good. So let's walk through specifically January 6th, which again is what's being charged. Oh, good. Oh, thank you. Why Pence could not do what he was being asked? Right. So the electors chosen by the states based off of the state law. Now, under the Electoral Count Act, those electoral certificates are sent into the Senate and they're counted. Now, all of that's all taken care of already. So the vice president just literally walks in the door, takes one thing from one spot, puts it into another spot, and then we're done. That's literally all the vice president can do. Everything regarding the electors has already been done before the ceremony. So what they were trying to do is they were trying to get the vice president to say, I'm not going to take these papers and file them. I'm going to say these papers are invalid. He can't do that. His role is literally to move papers from one spot to the other. That's it. So if for some reason he was physically unable to do that, somebody else would come in and people would be like, oh my gosh, he's supposed to do that under the Constitution, but, he broke his leg or something. But it literally is moving papers from one place to another. The electors themselves, all of that is chosen, all of them are done completely by statute and federal law. So the vice president has no authority, no jurisdiction whatsoever to do that. Yeah, he can't send anything back to the state. He's got no authority to do that. None of that. The states can independently say, hey, we want to recertify. The Congress can somehow step in and say, hey, we think there's a problem here. But the vice president's role is ceremonial. That's all it is. We take papers from one side, we put them onto the other side. And there are many things in Congress that are just ceremonial, that we just do for kind of historical reference and just moving, one bill to another place in a certain way. And this was just another one of those. It didn't have anything to do with the actual law of electing. It was just, this role of moving one thing to the other thing because it was written in the Constitution. Yep. All right, so let's take a look. Let's walk through what happened here on the 6th. At 1 a.m., it was a long day for everybody, I think. Then both chambers would need to agree to change everything. Right. And, our chambers aren't agreeing to anything. For sure. Oh, you're welcome. Sure. Yeah, I mean, that's a good question. You don't need paper to tear up paper for confetti. Yeah, I mean, it could be like, I don't know. Could it be like that where we're going through and we're just shredding a piece of paper? I don't know. I don't think we could do that. I mean, I think there's backups to the papers. I'm totally forgetting the name of the show where she kept tearing up papers and saying, "Oh, it's not legitimate anymore." But anyway, I digress. But yeah, we can't do that. It doesn't work like that in the legal field. So, okay, here we go. At 1 a.m., the defendant issued a tweet that falsely claimed, quote, "If the vice president, Mike Pence, comes through for us, we will win the presidency. Many states want to decertify the mistake they made in certifying incorrect and even fraudulent numbers in a process not approved by their state legislatures," which it must be. Mike can send it back. Again, whoever's in charge of archiving these statements would be called in to specifically read the statement out. Yeah, poor Al Gore. All right, at 8:17 a.m., the defendant issued a tweet that falsely stated states want to correct their votes, which they now know were based on irregularities and fraud, plus corrupt process never received legislative approval, which is all, of course, incorrect. All Mike Pence has to do is send them back to the states, and we win. Do it, Mike. This is a time for extreme courage. So this, of course, could be seen as some pressure, some potential threats, public pressure to make sure that we've got that ceremony being obstructed. So that's more evidence to that. And whoever's the archivist is going to be reading that. It's borderline. It's borderline. I could see how this could be charged in a different way. There could be a couple of different charges that could come down into that area. So, all right, on the morning of January 6th, an agent of the defendant contacted a United States senator to ask him to hand-deliver documents to the vice president. So now we're getting into this issue of what the vice president's role really is, which just has to do with these documents. The agent then facilitated the receipt by the senator's staff of the fraudulent certificates signed by the defendant's fraudulent electors in Michigan and Wisconsin. That's some pretty damaging evidence. The other thing, I wonder who has these fraudulent certificates? Who has this evidence? Because these fraudulent certificates must be somewhere. So can you imagine actually having the actual fraudulent certificates that were signed by the fraudulent electors and bringing that in front of a jury? Right. And some of their names some of them were tricked. But yeah, those to actually have those documents of certificates with all of the time and energy it took into making them look correct. And now we have all of these to show to that jury that we had fake certificates. Right. So, which were believed not to have been delivered to the vice president or archivist by mail. All right. So they're saying, look, they didn't get delivered by mail. So here they are. When one of the senator's staffers contacted a staffer for the vice president by text message to arrange for delivery of what the senator's staffer had been told were alternate slates of electors, because the archivist didn't receive them, the vice president's staffer rejected them. So again, though, I'm wondering where those are. They sent them to the National Archive. It's a good question. That's a good question. Who would testify to those? That's a good question too. We could have, we could have the staffer. Are these the papers that they asked you to put in? Yes, they are. And did you reject them? Yes, I did. Interesting. I mean, it's a good question. Wisconsin burned theirs? Interesting. So again, if that's true, then we would say, so how were you involved in this case? Well, they hired me to burn the fake elector certificates. And when did you do that? On such and such day at such and such time. And why were you asked to burn the certificates? Well, because they were illegal. That could be some pretty significant testimony. Yeah. I mean, again, I'm just thinking out loud here of some things that could go down. But that would be pretty significant evidence for our jury to see. At 11:15 a.m., the defendant called the vice president and again pressured him to fraudulently reject or return Biden's legitimate electoral votes. The vice president again refused. Immediately after the call, the defendant decided to single out the vice president in public remarks he would make within the hour, reinserting language that he had personally drafted. And again, this goes to what his intent was. Earlier that morning, falsely claiming that the vice president had authority to send electoral votes to the states, but that advisors had previously successfully advocated be removed. Again, we're going to have lots of different testimony here, but primarily the vice president is going to come in as well to testify. So, did he ask you again? Yes, he did. Now, if you think about it, the vice president's testimony is going to be over and over and over again. And at 11:15, did he ask you? Yes, he did. And then at 12:10, did he ask you? Yes, he did. Just over and over and over again. How many times did the president ask you to reject the legitimate electors? That could be some pretty significant evidence. Pretty persuasive, I think. Earlier that morning, defendant had selected co-conspirator 2 to join co-conspirator 1 in giving public remarks before his own. When they did so based on knowingly false election fraud claims, co-conspirator 1 and co-conspirator 2 intensified pressure on the vice president to fraudulently obstruct the certification proceeding. So now, not only do we have the defendant asking the vice president, 10 different times? Now we've got co-conspirator 1 and co-conspirator 2 going after the vice president again to ask about this. So that's a lot. That's a lot of times. Yeah. That the vice president was really pulled in. Now, the vice president's really carrying a lot of pressure on his shoulders here because he's being asked repeatedly over and over and over again. And that's going to be some pretty significant testimony to just hear how many times, just quantity-wise, how many times he was asked to do this. Right. And, he's a pretty religious person. Quite frankly, the phone call on Christmas Day, I think, in my opinion, my humble opinion, I think that's pretty rough testimony when he's like, it was Christmas Day, it was wishing him a Merry Christmas, and all of a sudden he's asking me about these electors. I think that could be some pretty interesting. Yes, and that he had to be removed because of for his safety. Yep, absolutely. Can the sheer amount of circumstantial evidence transform that into hard evidence? I think a lot of people can mistakenly view circumstantial evidence in a negative light. If you think of direct evidence is a witness. So their testimony is direct evidence. So we call that in the legal field the best evidence is to have a direct testimony. But circumstantial evidence, those are the technical receipts that everyone's kind of been talking about. So blood work, DNA, x-rays, medical charts, whatever's involved, that is circumstantial evidence. So when we're talking about circumstantial evidence here, we're talking about those memos. That would be circumstantial evidence because it's not a person testifying about something they directly witnessed. But with all of these witnesses coming in with the kinds of circumstantial evidence involved here, there's really not that much circumstantial evidence. There's just a lot of direct evidence. So we don't really have so much. I mean, we don't have DNA. We don't have, what we have. We've got text messages. We've got emails. We've got video. We've got, these fraudulent certificates. I mean, that's all we have for circumstantial evidence. But we've got witnesses for each one of these different pieces of circumstantial evidence that's also testifying to the circumstances around it. Yes, direct testimony. Exactly. Well, Steve, technically, I mean, if you look at it academically, direct evidence is seen as the best. But honestly, if we're looking at criminal cases, our juries prefer circumstantial evidence. And I think most of our juries think of circumstantial evidence as the best. But technically, that witness, that victim, that's direct evidence is seen academically as the best. Although we all know that there can be problems with witnesses and testifying and so on. But our juries, they want that. They want to see that those DNA tests and all of that kind of evidence that can come in. They prefer that. So it kind of, it would be good, I think, for both of them. But in this particular case, again, we just have those and how the memos were written as well. I mean, the memos technically themselves is going to be seen as circumstantial evidence, but anyone receiving it is going to be directly testifying about it. So, okay. Let's take a look. Earlier that morning, the defendant had selected co-conspirator 2 to join co-conspirator 1 to give public remarks. Right. When they did so, based on knowingly false election fraud claims, co-conspirator 1 and 2 intensified that pressure on the vice president and to obstruct that certification proceeding. Co-conspirator 1 told the crowd that the vice president could, quote, cast the ECA aside, which is completely false, and unilaterally decide on the validity of these crooked ballots. He also lied when he claimed to have letters from 5 legislatures begging us. Now, as we already went through all the evidence, we had the leaders of all 5 of those legislatures. We had majority leaders in the House and in the Senate for all of those states, all saying and making public statements that their elections were not fraudulent. And in a couple of states, we had courts saying that. We had 2 Supreme Courts saying there was no fraud. So I have 5 letters from 5 legislatures begging us. That's going to be difficult with all of the other evidence. To send elector slates to the legislatures for review and called for trial by combat. So co-conspirator 1 here is going to be in a bit of trouble because, of course, this is an imminent lawless action. And so, we don't have that protection of the First Amendment in place. Co-conspirator 2 told the crowd, all we are demanding of Vice President Pence is this afternoon at 1 o'clock. He let the legislatures of the state look into this so we can get to the bottom of it. And the American people know whether we have control of the direction of our government or not. Now, this sentence in and of itself is a pure admission of an obstruction of this government proceeding. I mean, that's just a direct admission of it. We're demanding the vice president let the legislatures of the states look into this so we can get to the bottom of it. It's a direct admission statement that can be testified to. And then We can no longer live in a self-governing republic if we can't get the answer to this question. So we've got, again, some of that incitement language along with this clear admission that we want the proceeding to be obstructed. So, again, and then they go in and explain we've got a federal government function here, and we've got an obstruction where we're interfering with others' rights to votes, which has been charged. Now, let's bump down to this next piece of evidence that would be presented in trial. We've got the vice president could alter the outcome of the election results, stating, again, here's a huge claim that would be read into the record. It's possible. I hope Mike is going to do the right thing. I hope so, because if Mike Pence does the right thing, we win the election. All he has to do, this is from the number one, or certainly one of the top constitutional lawyers in our country. He has the absolute right to do it. We're supposed to protect our country, support our Constitution, and protect our Constitution. States want to revote. The states got defrauded. They were given false information. They voted on it. Now they want to recertify. They want it back. All Vice President Pence has to do is send it back to the states. To recertify, we become president and you are the happiest people. So this is that moment where some people are saying, this is First Amendment political speech. And when you look at this analysis, if you look at this as freedom of speech, all right, so let's break this down. I hope Mike is going to do the right thing. Okay, that's fine. I hope so. That's fine. Because if Mike Pence does the right thing, we win the election. Okay, that could be. You can go forward and talk about that if that's your thoughts. That's no problem. All he has to do, this is from the number one, or certainly one of the top constitutional lawyers in our country. Okay, again, that speech is fine. He has the absolute right to do it. Now we're getting into some questionable words. Does he really have that absolute right? What are we implying here? We're supposed to protect our country, support our Constitution, and protect our Constitution. So that could be seen again. That's fine. That's also political speech. States want to revote. Now, this is a direct statement regarding voting and the electoral college electoral process. This is it right here. The states got defrauded. Again, the implication is that their electors were incorrectly counted, incorrectly put forward to go to the proceeding. They were given false information. And so the implication is the electors are false. They voted on it, which is incorrect. Now they want to recertify, which recertification would obstruct that government proceeding. This phrase right here, if we're asking the states to recertify, we're asking for the proceeding to be obstructed. They want it back. Maybe all Vice President Pence has to do is send it back. So now he's asking the vice president to interrupt the ceremony, to obstruct the government process. That is what he's saying. Is this political speech? Like, I believe this, I believe that, we're supposed to protect our country? No, he's saying the vice president has to send it back to the states to recertify. That's an action that he's asking of the vice president to interrupt a proceeding, which is what's being charged. And we become president and you are the happiest people. Maybe this last piece could be seen as political speech. But this speech here, this speech is asking someone to commit a particular offense, which would be the interruption or obstruction of an official proceeding. It literally doesn't say that. No, it literally says that. It literally says that. I mean, it does. Right. Those are his literal words. So he's saying the states want to revote. If that was true, which it's not, if the states wanted to revote, we would have to stop or obstruct the proceeding that was about to occur. Yeah, I mean, it does. There's nothing I can do to, support what I'm saying when I'm just reading the exact words that were being used. That's really it. They did not want to revote. No, every single state testified either through their Supreme Court in Nevada and Wisconsin, through their Senate majority leader in 3 of the states, I think, plus the leader in their House of Representatives. Every single state said there was no fraud and that their electors had been elected properly. Every single state. That's what, 15 pages of the indictment goes through, is that every single state wrote letters, had judicial opinions, and all of that saying that there was nothing wrong. So this statement's false, but whether or not he thinks this is false or not, honestly, is irrelevant. What's relevant is he's saying they want to revote, meaning the proceeding cannot go forward, and the charge is obstruction of the proceeding. So even if that was somehow true, he's obstructing a proceeding that's going forward, which is the charge. Okay? So when they're saying this is all political speech, no, this is political speech. Okay, that's fine. This is, questionable. But they're saying the states want to revote. The states got defrauded. They were given false information. They voted on it. Now they want to recertify. If you're recertifying, you're interrupting the process that we're going through. That's it. I mean, it's just that simple. There's no political speech here. This is saying the states want to revote, so we need to stop the ceremony that's going forward, which is what we've been charged with. Obstructing certification of a fraudulent election is patriotic. Perhaps it's patriotic, but it's also illegal, and it's against the law. I mean, it's against the federal law. That's what we're talking about. You can be as patriotic as you want, but if you violate the law, you get charged with violating the law. I mean, that's just how it is. So, go for it. Be patriotic. I'm all about that. But, you're still breaking the law. And, it's this idea that, if we have this miscarriage of justice, then we need to go forward and do whatever we can in order to correct it. And it's like, this is 2020 and 21. And I mean, what are we talking about? We're not in the Wild West in Texas land. We've got rules here. Actually, Texas even has rules, quite frankly. And I say that lovingly. I'm originally from San Antonio. But look, I'm saying, we've got rules. And, if we look to the Brandenburg versus Ohio case, we had a group of people saying there's going to be trouble, essentially, in River City if you guys don't believe what we believe. And, the Supreme Court said that's okay. You can say that so long as there's not imminent lawless action. If there's imminent lawless action, you may not say that. You cannot do that. You're not going to be protected. Right. Right. I mean, it's just like, I get it. You want to be like, fight the good fight and stand up for freedom. And this was wrong. And it's like every single state said their election was fine. So there's a misunderstanding somehow, despite hundreds of people explaining that there was no fraud. But even if he completely misunderstood and really thought the states wanted to revote and truly believe that, that's fine. He's still asking for a criminal action to be done by stopping the proceeding from happening. So usually what we do when we've got a problem, when we feel something illegal is going on in the legal field, we wait and then we file. So what we do if there's a problem, if I feel I've been pulled over illegally, I wait and I file it in court. If I feel my rights have been taken away from me, I wait and I file it in court. I don't storm the jail person. I don't go into court and scream at the judge. I'm like, this is awful. I've got a First Amendment right to say whatever I want. No, we wait. We file in court. And here we had over 60 cases filed, and all of them said there was no fraud. So that's kind of how that's kind of how this works. And I think that argument is being made a lot. And I get it. I mean, I get it. But we're also, I mean, this isn't 1864. We don't live in 1864 where we get to go and just say, hey, I disagree, so let's, go for it. No, I mean, you don't. You wait. You file it in court. Like, we're civilized people here, supposedly. So, yeah. Again, and I get it. I get it. We're patriotic, and he was like, oh, this is awful, let's stop it. And, well, you can't. If there's a law against it, you still can't break the law. I mean, even if you believed it, even if you did, you still just can't break the law. What do you do when the court is corrupt? Well, you file against the court. If that court's still corrupt, then you go to the next court, and then you go to the next one until you get it taken care of. That's how you do it. That's just how you do it. That's the process. Once we toss out law and order, once we toss out the federal law or the state laws governing the people and just decide to do whatever we want, then that's when we have complete and total anarchy. I mean, that's just it. Some of our laws are kind of cruddy. That's true. I get it. But it doesn't mean you can just say, well, I'm not going to abide by that law because I think it's a crappy law. I mean, that's just not how it works. You challenge it, you vote, you get people to go in and change the law. You take the law to court and you challenge it. But you can't just be like, hey, I don't like your law, so I'm going to do what I want. Like, no, you do that, you can get arrested. That's what happens. It doesn't matter who you are. You can be the president. You can be Joe Schmo down the street who drank too much and decided to walk around downtown. I mean, that's how it is. Like, I should be able to drink all I want. I'm free. But no, you can't. There's rules called public intox. You can't do that. It's true. The elite do have absolute advantages. Absolutely. And so that's, we got to figure out how to keep them in check. We do what we can with that. But yes. What are his potential punishments for alleged crimes? These are charged as felonies. And so whatever level felony, they have a minimum, or they don't have a minimum, but there's like a maximum amount that you can be charged for that. So I think they're like 20 years each, I think. I believe. I haven't really looked at the sentencing because I find it to be too premature. It's way too premature to look at the sentencing, but I can understand why people do. But Joe Schmo can be president. True. But Joe Schmo, if he's drinking in public, can get charged and go serve his time, then come back out and try again. 55 max years. Okay. Could be. Political ones know the loopholes. Yeah, it's true. But, here's the thing, is that there are plenty of us that are not political, and we also know the loopholes, and we also know how to take care of the loopholes. So the best way to handle a loophole is to know what the law actually says and to know what the facts are. That's how you deal with the loophole issues. Joe Schmo doesn't have enough money. Well, if he's got enough money to go down to Main Street. No, I'm just kidding. Yeah, I mean, I have a lot of pipe dreams. This certainly isn't one of them. I've got other things on my dream schedule here. Money can help you get through and navigate the justice system, but if you're telling me all of the judges in the entire United States are bought and paid for, I would disagree with that. Maybe some of them, sure, but I would disagree that every single one of them is bought and paid for. That's just not facts. Just sheer numbers wise, that's not facts. Yeah, and I mean, the whole thing is pretty disheartening, the whole thing. And you don't want to see this. You don't want to see this from a president. You don't want to see this kind of action, that's being alleged here. That's unfortunate. And our senators and so on. It's heartbreaking. But it's also, I mean, that's what the law is. The law said don't interrupt the government proceeding. And if you do that, then, you can get charged. So, yeah. I think we all have some biases for sure. And I think our judges, well, I mean, I've got Judge Cannon gets a lot of flack and I understand why, but I haven't seen anything from her that's led me to believe that she can't be appropriate in her role as a judge yet. I mean, that could change, but I don't think so. Physical paper notes written in. Oh, I wish I knew how to write Mandarin. I don't. I think it's very, very pretty language in my opinion, but no, I'm afraid not. Maybe Korean. I'm working on it. Let's go back to the indictment. Yes, we've had lots of talk. So this is really the turning point, I think, in the indictment when we've got some questions. Yeah. Outcome determinative fraud. So, I think with expand on that. When we have elections, and it's always been this way, you've always got people kind of coming in and screwing with things, but it's never to a level that, causes us any harm. That's just the history of our country. It's just not been that way. And that's how it is. So what they're specifically saying is, there may have been, a fraud here and there, but that's normal. It happens in all elections and has since the beginning of our election time. So they're being very specific and they're saying, look, there's been absolutely no outcome determinative fraud. So if any fraud did occur, it certainly wasn't outcome determinative, meaning it was not relevant to this case. So I think we're really specifying here that if somebody, in Wyoming decided to, pull a fast one on their local election for school board, that's not what we're talking about. We're talking about outcome determinative fraud that would somehow impact the presidential election. None of that was at play here. So, whoever's in Wyoming messing around with the school board, we're not dealing with that situation. So we're kind of just clarifying that up. Yes, both sides have to agree on the jury, and they both have an equal amount of power in choosing the jury. Yeah, and that's how it should be. I mean, that's absolutely how it should be. We've got a lot of, yep. Postal workers steal mail. All right. I don't see the relevance in that statement. Are you saying then, are you trying to say that the postal workers have conspired to pick the president? Is that what you're saying? Oh my goodness. Oh my goodness, seriously? Oh my gosh. Have you spoken to a postal worker lately? You think they've got time to be working that level? They're just trying to survive, man. So they'd eliminate Democratic votes. I'm not sure what you mean by that. I think any vote is a Democratic vote, right? Do you mean the Democratic Party vote? Postal, yeah. I mean, I don't know. They're busy trying to make it through the day, those poor postal workers, bringing in the postal workers. Oh my goodness. Oh my goodness. Oh no, blind to the corrupt system. Oh no, I've been living in the system for a very long time. I'm fully aware of what's out there. Fully aware. That's why I recognize when I see something that is absolutely not true. Because I do know what really happens. I do. Okay, listen, David, I don't know what you're doing, but I'm going to need you to calm down, sir. All right. So, yeah. We don't need to go into Asia politics here at this point. I got enough on my plate. I'm not really renegotiating any of the situations that way. You guys are just right. I wish I was a battery. I'd have more energy. I need more energy. Outcome would have been a landslide if voter fraud by mail. There would have been a lot of indications, and there were a lot of checks put into place for fraud. And, that's how the system's always worked. And if you've ever worked a campaign, if you've ever worked an election, you know how things are kind of kept separately. And I'm not saying there aren't problems. I'm just saying you want merch that says, oh my goodness, I have to work on that. I've been saying that a lot lately, but yeah, I would, we do. None of our elections are perfect, but to have this kind of fraud is just not reality. That's just not what happens. It's just not. So it can happen, but it hasn't yet. So, I think everybody was super careful with the 2020 election, and the presidency should be dissolved into another bicameral legislature. Well, there were a lot of votes for that in the beginning. That was something that was definitely debated before we put together Article 1 and 2. That was a huge question, even for the Articles of Confederation. I'm not sure I'm a big fan of that because I feel like we would not really get much done, but I don't know. I guess I'm up for looking at anything at this point. If you want to take a look, why not? Why not? How would that work? Could it work? I don't know. Microscopic amounts of fraud in every election always has been that way. Correct. That's correct. Absolutely. We've always had little bits and bobs of issues going on. But nothing to a point that it would affect an election in any kind of a significant way as of to date. That could happen, but it just isn't. At what point you wouldn't be able to run? Technically, under the 14th Amendment, we would need a conviction of treason, or we would need a conviction of sedition. There's been some talk, and someone had brought it up on one of my lives before, of a what's it called, a quo warranto, which is a kind of a writ where you can say someone doesn't have appropriate authority. So there's been some chat about that, but I'm not sure that could be utilized. I'm not really sure. I mean, of course, we can have some legislation proposed. We could have different kinds of things put into place to kind of fix things. But I think it's a hole in our Constitution, quite frankly. I don't think we ever realized that something like this would happen like this. There's no way to be able to predict it. So it would take a constitutional amendment to really close the hole, to close the situation up. But in the interim, there are a few Band-Aid operations that could be done. But until there's a conviction, nothing can be done unless there were some kind of special condition laws written or put into place. It would be very difficult. Here, the situation really comes down to, we haven't chosen a Republican candidate yet. And I get the polls, I get all the numbers, I get that. I see what those numbers are. But, there are plenty of Republican options available. And so people will really, I think the primary will be helpful in determining what really will go on. Also, in the history of our country, the incumbent tends to win, but it doesn't always happen. But there are some Republican candidates that are just out there campaigning their hearts out. And I think for them to not even be considered because of, this element of star quality, I think is just unfortunate. In my humble opinion, I think everyone should have a chance and not necessarily be taken off of the table just because someone is, so bright with that. So, yeah, we'll see. Yes, I'm going to need to kind of wrap this up here because we really don't have much left. So I will just kind of go back through and we'll just finish this up a little bit here. All right, so after the defendant falsely stated that the Pennsylvania legislature wanted to recertify their votes, they want to recertify, but the only way that can happen is if Mike Pence agrees to send it back. The crowd began to chant, send it back. So again, we've got more of this language here. This isn't in that category of political speech where they're saying, hey, I believe in this, I believe in that, or I believe there's a problem. This is an actual request. We're wanting them to recertify. And by doing that, we're interrupting the official government proceeding. The defendant also said that regular rules no longer applied, stating, and fraud breaks up everything, doesn't it? when you catch somebody in fraud, you're allowed to go by very different rules. Now, this, honestly, if anyone's looked through the trial transcripts or any of the information in the O.J. Simpson case in Las Vegas, very similar language was used. And that's incorrect. That's really not how the law works. But this could be to show the intent, where he's saying, maybe I do know that what I'm doing is not right, but because fraud's involved, I can kind of do whatever I want. I don't know. I don't know if that's what he's saying or not, but that's the implication. Finally, after exhorting that we fight like hell, and if you don't fight like hell, you're not going to have a country anymore. That's some pretty aggressive language. Is this political speech? Now we're getting into a phase where I'm saying, yeah, that could be seen as political speech, but it's also inciting speech, which again is not protected under the Brandenburg test. The defendant directed the people in front of him to head to the Capitol, suggesting he was going with them, and then told them to give members of Congress the kind of pride and boldness that they need to take back our country. Now, this particular sentence could be seen again as political speech, although this is so vague, I'm not sure the implication of a lawless action could be made from that. So that's something that could be looked at in several different ways. But this kind of language here, this last piece, is not as strong as this indication that, you're not going to have a country anymore if you don't fight. And so that implication is that we need to have a fight. So then that takes us into the exploitation of the violence and the chaos at the Capitol. And I'm specifically looking here to the evidence, so that's why I'm flipping through to the next page. So this goes into what the Vice President Pence was kind of going through at the time. And a direct quote, Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent and inaccurate ones that they were asked to previously certify. USA demands the truth. And again, is this political speech? Well, he's saying the states wanted to recertify. In order to do that, there would have had to have been this interruption. So even though we've got all these issues going on, he's saying the vice president isn't doing what I want him to do. Now, is that political speech? Maybe. But this idea that the states wanted to recertify, that would directly impact the proceeding. 1 minute later, the United States Secret Service was forced to evacuate the vice president to a secure location. This is the moment in time where we have our obstruction, when we literally have a government proceeding that's being interrupted because one of the biggest players involved is having to be removed from the secure location. So put into a secure location. He's having to be removed. So now we've got the proceeding interrupted. Hold on. I just noticed. I don't speak Russian here. Just for anyone who is interested, sorry. So if you want to make a comment, you'll have to put it in English or French or Latin. That's when yes. Okay, so again, this is that proceeding was put on hold, was obstructed because the vice president could not be involved because of what was being said here. At the Capitol throughout the afternoon, members of the crowd chanted these phrases, which seem to show there's some incitement going on, some violence, lawless actions here. The defendant repeatedly refused to approve a message directing rioters to leave the Capitol as urged by his senior advisors. So this language talking about what he was refusing to do goes to intent. Like, why would he not help kind of diffuse the situation? Next, at 2:38 p.m., please support our Capitol Police, law enforcement. They're truly on the side of our country. Stay peaceful. All right. I'm asking for everyone in the U.S. Capitol to remain peaceful, no violence. Remember, we are the party of law and order. Respect the law and our great men and women in blue. Thank you. So these statements, I think, could be seen as political speech. That could be freedom of speech there. At 3 p.m., defendant had a phone call with the minority leader of the United House, or the United States House of Representatives, defendant told the minority leader that the crowd at the Capitol was more upset about the election than the minority leader. Again, this goes to intent on how they're feeling, how he's feeling about this situation. So again, we're just walking through the bits of evidence here that we've got for what actually happened on January 6th. At 4:17, the defendant released a video message on Twitter, and this could be included as evidence as well, this video message. And there's a quote: "We had an election that was stolen from us, and finally asked individuals to leave the Capitol while telling them that they were very special and that we love you." So it's possible that this could be seen as political speech. The election was stolen from us, and you're special and we love you, sure. But it also goes to intent and to what's going on with him at the moment. What's his response to the aggression and the obstruction of the proceeding? Well, he's saying the election was stolen, but we love you. So that could be seen as that. Yeah, intent. I mean, it can go to his rationale, how he was feeling in that moment. I'm not sure what the strategy would be for that, but I could see that's why they would use it. Now at 4:17, tweet: "The defendant joined others in the outer Oval Office to watch the attack on the Capitol." See, this is what happens when they try to steal an election. That goes to intent and knowledge. These people are angry. These people are really angry about it. This is what happens. So again, there's kind of this acceptance of the behavior. So maybe knowing that this could happen, knowing that this could incite lawless actions, it's possible. 6:01 p.m., the defendant tweeted, "These are the things and events that happen when a sacred landslide election victory is so unceremoniously and viciously stripped away from the great patriots who have been badly and unfairly treated for so long." I don't know. Is that inciting language? Possible. It's possible. "Go home with love and in peace. Remember this day forever." On the evening of January 6th, the defendant co-conspirator 1 attempted to exploit the violence and chaos at the Capitol by calling lawmakers to convince them, based on knowingly false claims of election fraud, to delay the certification, including the defendant, through the White House aides, attempted to reach 2 United States senators at 6 p.m. So we've got more people that can testify. The election was stolen. Okay, listen. The election was stolen. Oh my gosh. Oh my goodness. Oh. Boy, I just look away to read through the document and things get a little bit wonky out here. Yeah, let me just take a minute here. I don't even play. If we want to talk politics, that's fine, but blatantly false information is not here. It can be called BS. I don't mind that. Yep, you can call it BS all you want. That's absolutely fine. You don't know what he felt true. That's true. Could be a hero. And I think I've caught back up again. Okay, thank you. Thank you very much. Appreciate it. LOL, French fry. I'm sorry, I don't speak that language. That person was correct. You do need merch. Oh my goodness. Maybe I am wasting my time, but I'm choosing to waste my time, and I'm happy to do it. Turn the comments off. I might. Yeah, they're coming in and screaming. I'm like just coming down to the end here. Yes, no, I know. You all have been hanging out with me. I'm so thankful for it. So, good. Okay, back in. Let's dive right back in here and get to the last bits and bobs. All right, so we've got the White House aides that can be contacted. Now, from 7:59 to 7:18 p.m., 6:59 to 7:18, co-conspirator 1 placed calls to 5 United States senators and 1 United States representative. Now, I'm wondering how this information could come in. Do we have phone records, maybe? I'm wondering. Were phone records subpoenaed? Do we have... Oh, thank you. Thank you so much. We must have some kind of evidence showing calls placed to these senators, and that information could come out. during the discovery process. Co-conspirator 6 attempted to confirm phone numbers for 6 United States senators who the defendant had directed co-conspirator 1 to call, and to attempt to enlist in further delaying the certification. So now we're going to say, what evidence are we going to need to show that they're trying to enlist the assistance? So what would we need for that? What kind of information would we have? So how did we confirm the phone numbers? Who was involved in that? And then by confirming the phone numbers, was he talking to someone about these phone numbers and explaining he wanted to call them in order to get them to help? So now we've got another witness that could be involved as well. In one of the calls, co-conspirator 1 left a voicemail intended for a United States senator that said, "We need you, our Republican friends, to try to just slow it down." Again, the inference is that we're slowing down an official government proceeding that's seen as obstruction, so we can get these legislatures to get more information to you. And I know they're reconvening at 8 tonight, but the only strategy we can follow is to object to numerous states and raise issues so that we can get ourselves into tomorrow, ideally until the end of tomorrow. These are all statements of admissions of trying to obstruct the government proceeding. That's what this is. He called the wrong number. Did he? Oh my goodness. Oh, wrong number. Oh, all right. Here we go. We're coming down to the end of it here. Oh my goodness. In another message intended for another United States senator, co-conspirator 1 repeated knowingly false allegations of election fraud. And of course, we're going to have this recording that can come in. And probably the easiest thing would be to pull this U.S. senator in to testify and say, "Hey, did you receive a voice message?" "Yes, I did." "And what did that voice message say?" "It said blah, blah, blah. Can we play it?" "Yes, we can." And then it's admitted into evidence. That's typically how that would go. Including that the vote counts certified by the states to Congress were incorrect, and that the governors who had certified knew they were incorrect, that, quote, illegal immigrants had voted in substantial numbers in Arizona, and that Georgia gave you a number in which 65,000 people who were underage voted. Co-conspirator 1 also claimed that the vice president's action had been surprising and asked the senator to, quote, object to every state and kind of spread this out a little bit like a filibuster. So we're going to, I have no doubt this particular senator is going to be called to testify, because he's going to testify. He's going to need to play his voicemail. He's going to need to say these statements that were said to him, which are admissions. And also this special request on how to obstruct that proceeding, so he can testify to all of those different statements. Yep. Yep, he can. Yep. He would be called in. Now, I don't know who this senator is, but he's going to play a critical role. This is a U.S. state senator and a United States senator. Sorry, I'm not sure what state he is the senator of. But he would. Oh, hi. Welcome. All right. So he's going to be testifying at 7:01 while co-conspirator 1 was calling United States senators on behalf of the defendant. The White House counsel called the defendant to ask him to withdraw any objections and allow the certification. So the White House counsel, of course, as we know, is going to be called to testify, and he's going to say, "I called the defendant. I asked him to withdraw the objections, allow the certification. The defendant refused." So we have another situation where they're saying, "Hey, you can halt all of this," and he's saying, "I'm not going to." Again, going to intent. The attack on the Capitol obstructed and delayed the certification for approximately 6 hours. That can be testified to by multiple people. We could have the Speaker of the House come in and talk about it. We could ask the leaders of the Senate to come in as well. How long were you delayed? And they would testify to that. Until the State and House of Representatives came back into session separately at 8:06 p.m. and 9:02 p.m. respectively, and came together in a joint session. So whoever had to convene that joint session could come in and testify. At 11:44, co-conspirator 2 emailed the vice president's counsel. So his lawyer, again, is involved in this at this point. Co-conspirator 2 wrote, quote, "I implore you to consider one more relatively minor violation of the ECA and adjourn for 10 days to allow the legislatures to finish their investigations. as well as to allow for a full forensic and audit of the massive amount of illegal activity that occurred here. And again, as we've seen from all of the states, there's been no fraud. So at 3, yes, we're almost there. Oh my gosh, so many of you have been with me for hours. I'm so thankful. All right, at 3:41 a.m. on January 7th, as President of the Senate, the Vice President announced the certified results of the 2020 presidential election in favor of Biden. Boom. Now we're done. Defendant and his co-conspirators committed one or more acts to affect the object of the conspiracy alleged in these paragraphs. Okay, so there we go. Whew. Now, the rest of the counts do not have evidence. The evidence was stated out earlier that we had gone through kind of, piece by piece to discuss about, what's covered by the First Amendment, what political speech are we talking about, and versus, illegal speech. Like if you're asking someone to commit a crime or you're trying to commit a crime, all of those can be charged. Language, speech can be charged. Depending on the statute here. So we had all of that, went through that. Who can testify? Can the archivist come in and testify about the tweets, about the videos? Who's going to be able to come in and talk about the phone calls that they received and the different things that were put out for evidence, for statements, and so on. So there are a lot of moving parts here and, hundreds and hundreds of witnesses. So, and, we started this whole conversation saying at the very beginning, when we walked through, let me just pull the page back up again. We walked through, I think this list really is one of the most accurate pieces on page 7. And we looked at all of these different people and all of them saying there was no fraud, there were no problems with the election, just over and over and over again, and assessing their credibility. Can we believe the vice president? Can we believe the senior leaders of the Justice Department, the director of national intelligence? Just over and over and over again, this overwhelming number of people, his own staffers, state officials, courts, everyone is saying, there was no fraud, and there's just so much evidence. And so this question of there's no evidence. It's there is. This, you may not like or agree with the evidence, and it may not be enough beyond a reasonable doubt. That's what a trial jury is for. But there is evidence. This is, according to the rules, we have evidence here, and we have witnesses, and we have direct evidence, we have circumstantial evidence, we have all different categories of people too. So, take out anyone you don't like and you've still got 8 more types of witnesses you can put in. So the question isn't, is there any evidence? The question is there evidence to prove beyond a reasonable doubt? And that question is for the jury. Oh no, this is not the only evidence. Oh no. We only need probable cause for an indictment. This is just the tip of the iceberg. And honestly, as I said before too, we did have all of those January 6th hearings with all of that testimony. Now, did I take the time and pay attention to those at the time? No, because it was Congress, right? But now we've got an indictment from a court. And if we're looking to see what evidence to back it up, we've got the testimony of over 200 witnesses who were sworn in and testifying in front of Congress. And their evidence, their testimony, that's the information that is available to the public. But also so much of that is not included in here. There's a lot more stuff that was going on that's not included. So I think that, it's really, there's a lot. There's a lot of evidence available. And you can go back and look at those hearings just with the knowledge that there is an indictment now on record. This isn't just about congressional hearings. We actually have a legal proceeding going forward. And so when you look at those hearings and the testimony, you can kind of look at it with fresh eyes if you look at it from a criminal law point of view. How long will the trial last? I don't know, a couple hundred witnesses with this level of evidence. I don't know what the defense is going to put on. They don't have to put on anything. Of course, the burden's on the state. or the government, I really have no idea. I mean, 6 weeks minimum, but that's looking at voir dire is probably going to take a couple weeks minimum. I mean, that's generous, I think. It's going to take a really long time to find a good pool of impartial jurors. It's going to take a long time. I love a good legal document. Oh, well, good. I'm glad to hear that. Oh, you're welcome. You're welcome. Yes. Oh, no, I'm happy to. I'm happy to just kind of walk through it, explain some of the ins and outs, how we use evidence, how it's presented in trial. I think there's a lot of pieces to it that, we just don't, that's not something we really talk about. So hopefully I can help out just to understand what it's all about. Again, we don't have proof beyond a reasonable doubt. We don't have a trial here. We have an indictment. That's probable cause. Okay, what pen am I using? Somebody asked me that. I'm not really sure. It's this. It's whatever this is. I'm not sure. Whatever this is, that's the pen. Oh. Yeah. I mean, it's okay. You don't have to believe me. In fact, I encourage everyone, go look it up for yourself. Go look up the rules. Look up the law. Look up the indictment. Don't take my word for it. Go find it yourself. I'm just giving you some things to think about, some questions to ask, and some ways to go about analyzing it. But trust, verify it for yourself. Absolutely. Don't just take my word on it. Go forward and learn about it and understand. That's really what my goal is. I'm trying to get, ask those questions and, keep asking them until you get the answers that you need in order to make a decision yourself. Can you define for people how to verify a legal resource? Yes. We've got, there's lots of, oh my goodness. We have lots of sources, and what you want to make sure, if you're looking at a court document in particular, because all of this is public, what you're going to want to look for is the court file and the date that it's been filed. That's how you know you've got a court document. Oops, let me move it down. Maybe you can't see that. How about now? There we go. And then when you're looking to legal resources, which are all available online, free, you can look them up. You want to put your state in and then whatever rules you're looking for. If it's criminal, you look for the rules of evidence. And then you'll want to look, if you're interested in other rules, we have the rules of criminal procedure at federal. And your state has the same thing, just with your state's name. But these are our procedural rules. If you're looking for substantive law, you're going to want to look to your state's code section. So I've got an example that I was using earlier. So let's just say you want to know what the law says on what the elements are for a law. You would just look up your state and put in the name of the offense. So I was looking up the definition for assault for Texas. So you put in Texas, you put in assault, and it'll pull up that code section. This is what you want it to look like. If it's something that's included in an article with a bunch of stuff at the top and a bunch of stuff at the bottom, that's just someone going on and on about it. But if you want to see the law itself, this is the format. Oh, thank you. This is the format it should look like. It should look extremely dry and in an outline format. Now, if you're in Louisiana, they're a bit different. Their code sections are written different, and their language is just a little bit different. So don't get thrown by that. But, like, for example, here's a Florida statute. We all put our statutes in this outline format. So you look your state up, you look your crime up, and you will be able to pull that code section up. And then, of course, if you're looking in the federal code, I went through earlier, I was going through all of the crimes that involve speech, where you can't use freedom of speech as a defense. So it's an element. But this is, list out of the criminal cases at a federal level, and that's just under Title 18. So when you're looking for substantive laws, you look to the code, the United States Code or your state code. If you're looking to the procedural rules, then you would look to your criminal procedure rules or your rules of evidence. So that's where you'll find your law when you're looking it up. I hope that helps. And case law, of course, is a whole nother animal, but that's a different world. Can you pin where we can get these documents and those books? These books, you certainly don't need these books. This is all available online. If you want to get the books, you can find these. There's lots of different versions of these kinds of books online, just through wherever you get, your books from. But online, like all of this is all on. Oh, thank you. All of this is online and you can just pull it up. I like to have a paper copy just so I can show everybody here. I find that to be really helpful. People tend to really appreciate looking through these kinds of things this way. Thank you. But it's online. If you want to look up your federal rules of evidence or your state rules of evidence, all of my state rules of evidence, I just have it bookmarked online. And so I just pull up the rule that I need at the time. So I don't necessarily need the book, but they are available if you're interested. I'm certainly not trying to endorse or, say that this is the book you need. It's just, this particular format is just easy for me because of the size. But all of your state code, any of your state codes, the federal code, all of your laws, they are all going to be online, and you can just pull out whatever section you need. And then, of course, we've got the Constitution. So, yes, I find paper to be better, too. I like to put notes on it, but I also think it's easier to share with other people. And I think that just goes back to, teaching. It tends to be easier to pull it up on a screen. I've tried to do a couple of lives where I've just had my computer screen up, but I just feel it's just really boring to see somebody type into a computer screen. So I find it more helpful for me to be able to explain things easier. But it is all available online, all available for free. And you would just go and look up your state and look up what rules you want. And paper doesn't need electricity. True story. Am I in a law firm? No, I'm not. I have my own practice. I've been very lucky. I was a planner. I was a very careful planner with my life, so I've been able to set things up so I could do my own thing. Why do states have their own constitution? Just because they've got different rules. They've got different necessities. There are parts of the Constitution in Texas that aren't in the Constitution in Wisconsin. And, California's Constitution is very different than the Constitution in Arkansas. Some parts are the same, but some parts are different. So it just depends on how they want to write their amendments up and the order that they want to write them in, too. So can we retain you? No. No. Oh, that's so kind of you to ask. No, I don't take any clients. I'm not taking any clients right now, but I don't take any through social media or anything. I don't do anything here that would be monetized or have any kind of payment involved whatsoever. I'm just here to educate, just plain straight up simple education. Do you have a license to practice in every state? No, I'm licensed to practice in my own state. I can practice federally if I have a case that would go up to federal court. I can be allowed to argue that case in federal court, which is how it works. But I'm licensed in my jurisdiction, and it's enough. It's enough for me. My one jurisdiction's plenty for me. So glad to see your lives. Oh, Law of the Wild. Thank you. Oh, I don't know about that. I'm just hoping that it's helpful for people to answer some questions for people. So hopefully it's helpful at least. What type of lawyer? I do a little bit of everything, but my background is in, I spent a lot of time in criminal law, and criminal law, constitutional law are the areas that I teach in evidence and criminal procedure, torts and litigation. I've also spent some time teaching those topics as well. So, and I've done seminars. I give different lectures and so on, depending on the situation, on specialty topics like the Second Amendment or the DACA cases. So kind of specialized cases like that as well. I just love to go and talk to people about it. So that's kind of what my area is. Oh, thank you. Oh my gosh, Rosie, that's so kind of you to say that. Oh, thank you so much. Oh, I'm glad. I'm glad it was helpful. Are there new case filings today? We still have, we've got the motion that came out for the DC case, the motion for exclusion of time under Speedy Trial Act that the defendant did file. It's only 2 pages. It's not that significant, but I don't see a response to that motion as of right now. So that is DC. We've got, yeah, that's the last motion. And there's a proposed order that went with that motion. And then in Florida, no, we don't have anything new. We don't have anything new in Florida. Just kind of keep my eyes on what's going on there. So tell the audience about mens rea. Yeah, mens rea, actus reus, we need an act, which is a criminal act, actus reus. We need mens rea, which is criminal intent, and those together equal corpus delicti, which is the body of the crime. So we have to have those 2 pieces proven beyond a reasonable doubt in court in order to go forward. So can you go over a DACA case? You know, I could do a live on DACA. I don't know if people are still interested in that, but yeah, I mean, it was interesting how the whole DACA situation came about because of the memos. I mean, it was all created because of executive branch memos. So it's kind of a fascinating situation. So it's very interesting, I think, how that all evolves. So I can put that on my list to do for sure, unless it's strict liability. Yeah. Ooh, strict liability. Yikes. Yep. Did you see what he said defamatory of the DA in Georgia? I didn't. Has it been recent? Was it today? I haven't heard that. When did your love of the law begin? That's a good question. Well, I'm about to be on MSNBC. What? I don't know about any of that. Honestly, I started my love of the law. It was just, I grew up extremely poor in a very, very impoverished family. And, I found a copy of the Constitution and just found it absolutely fascinating. So for some reason, it just really instilled a very patriotic tone, which I've always had, and had a military family background. So just kept pushing towards that goal, and was very lucky, and also worked really hard to be able to kind of get there. So I started working when I was 11 years old and paid cash under the table, which I do not suggest for anyone. But I think after that, I started looking into what my rights were. So that was important to me. Where do you find those speech cases? Well, which one, Riley? Which one are you talking about? I've got a whole bunch of freedom of speech cases. If you're talking about limitations on speeches, I've got a set of posts that I've done on my TikTok channel where I just go through lists of relevant First Amendment cases. So you can just click on it and I will take you through like the top 8 landmark cases for whichever one. The one right there. Do I have a freedom of speech case right here? We need the not legal advice. Post it. We do need the not legal advice. Post it back. Yes, this is not legal advice. This is legal education for anyone who's interested. Yes. Oh, yes. You're welcome, Brenda. Thank you for coming. I appreciate that. Yes, the Constitution, it has been revered, absolutely. And when you look at the history of it, I mean, it's not a pretty history. It's not really a super happy story, but I think it's a story of perseverance, in my opinion. I've been on MSNBC and CNN. It goes by fast. Oh, okay. Well, interesting. Yeah, I'm really trying to catch up here. Yes, for educational purposes only. That's right. I'm trying to figure out which case you're talking about. Oh, I feel terrible now. Maybe the Brandenburg case, Brandenburg versus Ohio, the imminent lawless action test is what you're talking about, or the NAACP case is the other case that uses the Brandenburg test. That's a very famous case also. And NAACP versus Claiborne Hardware Company, that was a 1982 case that has to do again with that imminent lawless action. So both of those are really key. You're on Tucker Carlson 6 months ago. Oh, okay. Well, good for you. Good for you. Yeah, I kind of, I don't really, what am I hearing in the background? I think that was my, I have very long hair and sometimes it has a mind of its own. So it kind of obstructs my vision sometimes. So, oh yeah, go for it. Oh, the GI Bill. Absolutely. You've earned that. You've absolutely earned that. Go for it. Texas v. Johnson. Yeah, we've got, that's the flag burning case. Yep. That's pivotal. Absolutely important. Absolutely. Very, very good case. Yep. Highly recommend. Hands are off. They're kind of on and off today. They're kind of in for a little bit, but then coming back out. So I think they're undecided, I think. Oh, I've been trying to figure out what I'm doing. Somehow something else is crossing over you. No, it's my hair. I've got I have a what's it called? A tripod situation going on here, and it has a spring, and sometimes my hair gets caught in it. So, yeah, sorry about that. Sorry about that. Need tort reform. Lawsuits bad for the economy. Oh my gosh, tort reform. Yes, I'm fully supportive of that. Absolutely. Absolutely. What's the document on the screen right now? This is, oh, okay, I get it. I'm sorry about that. It takes me a minute. I'm a little slow. I've been on for a couple hours, so I'm a little bit slow. Oh, good night to you too, Jilly Bean. You go on, have a great night. Thanks for coming. This is Title 18 of the United States Code, the Crimes and Criminal Procedure. And what I did was I just printed out the very first few pages, and I was going through and explaining, circling, different criminal offenses where if you use speech in certain ways, you can be charged criminally. So these are cases where First Amendment speech doesn't protect you. For example, like for arson, the threat of harm can be, or assault, sorry, the threat of a battery can be an assault. So just the threat, those words can be used to charge an assault. So that was just an example. And then we've got like extortion, fraud, false statements, all of these things that involve actual speech that can be charged criminally. So that's really what I was going on about here with explaining why this one was here. Yes, contracts, counterfeiting, lots of things like that. Tort law was the bane of your existence while getting your degree. Oh my goodness, yes. I taught torts and litigation for a few years, and I'm not sorry, but I'm not sure I would do it again. But it was interesting. Why does it take so long for the grand jury to address felony? Oh, that's a good question. A good question, and one I don't have a good answer to. I would say one of the biggest issues that we have with any kind of children cases are the credibility of the children. A lot of our juries struggle to really believe our children when they testify, unfortunately. So I would say that's one of the biggest issues, but I think that whole area of the law is one that is incredibly difficult for everyone involved, unfortunately, and needs to be looked at so much. Yeah, it's definitely not done the way that we would want it to be done. When you see what's written today, that there will come defamation. Yes, defamation is that's not protected by freedom of speech. That's why you can get charged with that. You can absolutely get charged with it. Yes, yeah, and it's just one of those areas of the law that is absolutely devastating. It's heartbreaking. Do you deal with criminal law? I do. I teach a lot of criminal law concepts. I don't take much for criminal cases anymore unless it's really necessary. I'm lucky I've been able to set myself up to be able to um, kind of been able to provide or explain things to people without having any problems. And with that, I'm just kind of able to be a free agent, do whatever I want. I'm very lucky. But I set things out. I started working on it when I was 17, so I've been at it for a while. Oh, good. I'm glad to hear that, Brandon. I'm glad it was interesting. I'm very glad to hear that. I do try my best, so I do my best when I can. But I had promised I would keep my lives a little bit shorter. I'm certainly not doing that tonight. So, am I shocked by the comments? No, it's not. It takes a lot to shock me. Maybe I shouldn't do that because it'll be a challenge now. But no, I really don't get shocked. I understand people hurt and people lash out, and I've been doing this for so many years. It doesn't bother me. I understand. Just plain false information, though, I just don't abide by that. But other than that, are you teaching at a university? Not right now. We've got classes coming back into session, but I am not teaching any classes currently. I'm kind of off the clock, so to speak, for the next couple of semesters, and I'm okay with that. So half these people aren't even, maybe. And, I just don't, honestly, I just look at it like if you've got something you've got to ask, that's fine. But if you are not, that's fine too. Thank you. Good night. Oh, yes. Good night to you as well. Good night to you as well. Criminal's where my heart was, but it should have been smart. Went to business. Oh, yeah. Criminal law will just eat you up and spit you out. It absolutely is difficult. It's very difficult. It's heartbreaking. Why is being Indian? Do you mean an indigenous person? Are you part of a tribe? Is that what you're talking about? You'll have to be a little bit more clear on that. Thank you for educating. Oh, you're welcome. You're welcome. Oh, you're welcome. You're welcome. I'm hoping this was helpful, interesting for people. Yes, Native. Okay. Well, I think, it's not a crime. We do have lots of different laws and such set out. In fact, I've done an entire live just on Indian treaties and Indian laws. I use the word Indian because that's how it's written in the statute, as well as our Native American cases, which again is written in the case law. But a lot of our indigenous laws and treaties and things, and I've done an entire live on that. It's on my Tube of You channel if you want to take a look at that. I think it's about 3 hours long, going through the most recent case, the break-in case, where they came back in with regards to water rights. Very controversial, so you can feel free to check those out. Yes. There's many different ways that it's written. Many different ways that we have written and categorized certain different sections. So I try to be, yes, the ICWA case is a very important case as well. I've pulled that. I did a full live on ICWA. I mean, that's probably, I'll be honest, those are probably the cases my biases come out. I am not very understanding when it comes to how our laws are written and treaties have been written. So that is one area that I'm not quite as impartial as I probably should be, but I do go into kind of the details of our different case laws and so on. So you can check that out if you're interested in that. But oh yeah, sure. Oh yeah, no problem. Mm-hmm. Yeah, I mean, it's a huge area of the law. It's an area of the law that has piqued my interest for years. So I think it just really needs to. It's an area, if I can help clarify, I'm happy to do it. Oh yeah, ICWA, of course. That was a good day for all of us when ICWA came through. We all kind of held our breath for a little bit. We weren't sure what was really going to happen. And the fact that it came down the way it came down, we were happy. That was good to see. Yeah, my Tube of You channel is the same as my name for my TikTok. So I'm up there. I am there for anyone who needs help going to sleep at night, listening to someone going on and on. Could I make a doc with my live schedule? Oh, I could do that. I've been thinking about that. I just wasn't sure if that would be helpful for people. but I certainly could. Oh, good night. On the East Coast, oh my goodness, yes, yes. Get some sleep. Good for you. Go on and rest up. Have I ever worked with the Innocence Project? I've dabbled in the Innocence Project. I've not done any representation. I've done research. I've done some support work, some consulting, but I haven't done any representation. I think it's an amazing program, honestly, in my opinion. So, okay, I will do that. I can make a schedule of my lives and just post a video on it. I do have a list of topics, and it kind of changes depending on what's going on. But yes, good night, and I hope to see you again. Thank you for coming by. But yeah, sure, I can post that and kind of give you some idea. Now, again, we would call this in the business, this is kind of a soft plea agreement, a soft yes, meaning, I may have to change the schedule as time goes on. But let me just make a note here to kind of put that together to give some people some ideas. I do have some cases that I'm hoping. Oh, good. I do have some cases that I'm going to be trying to get through. So yes, you're welcome. Good night to you as well. Oh, good night from Michigan. Oh, absolutely. Have a great night. Oh yeah, I think it should be taught at every level. I think at every level, a little bit, just kind of building on it, I think is very helpful. So absolutely. Now, with that, though, I'm afraid I will have to say goodnight to everyone. I'm looking here at the clock. I'm coming up, oh my goodness, coming up on 4 hours. So this is going to take a while to upload onto my TubeView channel. I tell you, I keep saying I'm going to make it shorter, and that's just not happening. But I will go ahead and sign off for tonight, everyone. Thank you again. Yes, thank you. Oh my gosh, if you've been here from the beginning, you are just heroes. Thank you so much for your support and all your wonderful questions and various things. So thank you very much. I will kind of put together a post on what my schedule will be looking like over the next few days to keep everyone up to date on that. So yes, you're all very welcome, and thank you all for coming. I appreciate it. I appreciate the time and effort that you've taken just to hang out with me tonight. So I'm hoping this has been insightful. Oh, thank you so much. Yes, I will keep at it the best that I can. Keep my schedule up and running here. So, and I'm thankful for you too, Vanessa. I'm so glad you could join me tonight. I'm very thankful. So have a wonderful night, everyone. I'm going to go ahead and sign off for now, and hope to catch you all at the next live. So have a great night, and